Well, good morning. I declare open this hearing of the Senate Legal and Constitutional Affairs Legislation Committee for the budget estimates. The Senate has referred to the committee the particulars of proposed expenditure for 2022-23 for the portfolios of Home Affairs and the Attorney-General and other related documents. These are budget estimates proceedings, and the outcomes to be heard during today's estimates are from the Attorney-General's portfolio. The committee has set Friday the 20th of May 2022 as the date by which answers to questions on notice are to be returned. The committee has also decided that written questions on notice should be provided to the Secretariat by 5 p.m. on Friday the 15th of April 2022. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you need assistance, the Secretariat has copies of the rules. The Senate, by resolution in 1999, endorsed the following test of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of a Department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I particularly draw the attention of witnesses to an order of the Senate of the 13th of May 2009 specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement which meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest which could result from the disclosure of the information or the document. A reminder that mobile phones should be switched off or turned to silent mode. Senators, departments and agencies have been provided with advice on the arrangements in place to ensure the budget estimates 2022-23 hearings are conducted in a COVID-safe manner. This guidance is also available from the Secretariat. The committee appreciates the cooperation of all attendees in adhering to these arrangements. In order to comply with social distancing requirements, senators and the Secretariat may use their electronic devices to communicate with one another during the hearing. We ask witnesses' forbearance to do so and apologise in advance for any discourtesy. Officers called upon for the first time to answer a question should state their full name and position for the Hansard record, and witnesses should speak clearly into the microphones. I'd like to welcome the Attorney-General, Senator the Honourable Michaelia Cash, this morning. I also call now officers from the Administrative Appeals Tribunal, and just a reminder that we have altered our published schedule and we are bringing on the agencies this morning. Welcome to officers from the AAT. Would you like to make an opening statement before we go to questions?
Yes, thank you, Chair. Jamie Krug, Registrar. Firstly, before I start my opening statement, I would like to thank the committee for allowing us to attend by video. The AAT offers individuals and organisations the opportunities for independent review of decisions made under more than 400 pieces of Commonwealth legislation. This includes decisions relating to Australian citizenship, child support, family assistance and social security, migration and refugee visas, the National Disability Insurance Scheme, taxation, workers' compensation and veteran support. The AAT is committed to providing a mechanism of review that is accessible to our users, as well as fair, just, economical, informal, proportionate and quick. Last week, on the 1st of April, we welcomed the appointment of Fiona Maher as a Judge of the Federal Court and President of the Administrative Appeals Tribunal, taking effect that day. Prior to Justice Maher's appointment, the Honourable Justice Bernard Collier, Judge of the Federal Court of Australia, acted as the AAT's President. On behalf of the AAT, I would like to take this opportunity to thank Justice Collier for her leadership during this time. I continue to act as Registrar of the Tribunal, providing the support to Justice Maher, assisted by a senior executive group. Following a fall in the number of applications received in 2021, primarily as a result of factors relating to the COVID-19 pandemic, applications to the AAT have grown steadily in 21-22. Lodgements continue to grow significantly in the NDIS division, and there is a return to higher lodgement levels in the migration caseload of the Migration and Refugee division. Our on-hand caseload remains large, particularly in the Migration and Refugee division. While we're able to make some inroads in 2021, there remains a substantial backlog of cases due to the significant growth in lodgements in that division over time. There has been a small decrease in the AAT's overall base appropriation in the 22-23 financial year, announced in the recent federal budget. Addressing our large and ageing backlog within existing resource constraints represents a significant challenge for the AAT in 22-23 and the forward years. We will continue to engage with the government regarding our ongoing resourcing needs. We welcome the approval to progress our work to replace our legacy case management systems with a single contemporary solution. This will offer enhanced service options for our users and improve productivity for the Tribunal. Finally, I acknowledge the publication last week of an interim report of the inquiry into the performance and integrity of Australia's administrative review system. The AAT looks forward to continuing to assist the inquiry over the coming months. Thank you, and I welcome questions from the committee.
Thank you very much, Mr. Crew. Look, I'm just going to start off with a couple of questions of a general nature, and then I'm sure Senator Carr will have some questions for you. Look, in previous estimates hearings, we have raised concerns as a committee as a whole about some significant administrative oversights by the AAT itself, particularly when it comes to the benchmarking of members' performance, including where the AAT was astonishingly reporting that a particular member had not done any work in a particular year when he had not even been sworn in, which evidenced that there were some major problems with your internal administration. I understand that there is a renewed focus on improving your systems. Could you just give the committee an update about where you are at in terms of improving your own internal systems?
Certainly, Chair. While we've had acting President and myself as acting Registrar, we've taken the opportunity to look at all aspects of our administration in an effort to prepare for an incoming President and an incoming Registrar so that they'll be well placed to make decisions about the path forward so that we can provide quality, accurate data and properly represent information in a way that's easily understood and accessible.
So just going to some of the issues about the benchmarking of members' performance. So, for instance, some very esteemed members of the AAT, including even former judges, were reflected upon in a very negative way. Examples such as, they might have started work in the April of the financial year, and then there was a report that they'd barely done any cases for that financial year without the appropriate context and information being provided. So I guess there is sort of deep concern about the AAT's internal processes, and we would see as a committee an urgent need to improve them. Can you give us the assurance that this is being treated urgently?
So, Senator, since those issues came to light, I think our responses to the Senate inquiry and provision of information, not only the data, but additional contextual information, as well as liaising with members in relation to that information for accurateness and completeness, has certainly been a priority. So I think we've gone some way already to demonstrating our reviews of how we provide information, and we'll continue to improve that. The improvement in our case management systems are, of course, one area that will assist us to more readily access information and provide that proper context. So there are a number of issues. The case management system has a priority for us in this coming financial year, but I think we've also demonstrated in our response to the Senate inquiry our capacity and willingness to provide that additional contextual information.
What is the timeline for making those improvements?
Well, I think we've made some already, as I indicated with our response to the Senate inquiry. The case management system is undergoing a proof of concept in terms of that aspect. But with the appointment of Justice Ma recently, there will be, of course, a renewed rigour to identifying the areas particularly that she wishes to pursue and how she wishes to provide context in relation to the performance of the tribunal.
Just on remuneration of members, in the past there's been some inconsistent practices with respect to the remuneration of part-time members across different divisions. Can you update the committee on what changes you've made in that respect to ensure greater equity and fairness across the board?
So as we may have indicated previously, there has been a move to part-time timesheets. So all divisions are now operating with part-time members under a time recording system where they record their time for a daily fee. So because that is now rolled out across all divisions, there may be, I think, one or two members who are under a previous recording system of finalisations that have been allocated work that hasn't yet been finalised. But we have now rolled out to the rest of the part-time members a time recording system.
On that note, I will now hand over to Senator Carr. I may have more questions in that respect, but Senator Carr.
Thank you very much. Minister, is the Prime Minister calling the election today?
Well, that is a decision for the Prime Minister. We're currently sitting in Senate estimates.
Yes, I know, but we're here today. The Prime Minister's in Canberra. I'm just wondering, following the decisions of the court at 2 o'clock, will there be an announcement?
Senator Carr, can I just remind all senators, including yourself, a very senior member of this committee, that the questions can only be asked in relation to the in relation to the operations and expenditure of the AAT.
I don't know what's happened. What happened? What have I said to upset you? I don't know.
No, not at all. I have great affection for you, Senator Carr.
I'm pleased to hear that. I'm pleased to. So you'll be able to.
But just reminding you what the purpose of estimates is.
No, the purpose of the estimates is to establish whether or not the Parliament's about to be prorogued, and I want to raise that in the context of the announcement that you made yesterday, Minister, about 19 more appointments to the AAT. I think that's a reasonable line of inquiry, because
Yes,
we're day before the
very-
election's called? I mean, is this how it operates now?
Senator Carr, would you like to ask those
Oh,
questions?
no, it's a question I asked you. Minister,
you.
did you make the 19 announcements, the announcement of the 19 new Liberal Party mates to the AAT in the context of the election being called within a very, very short period of time?
No, Senator Carr, I did not. You are correct. I did announce 19 new appointments to the AAT yesterday. Just in terms of the process, though, Senator Carr, as I think we all reflected on yesterday, you have been around for a very, very long time. You yourself have sat on this side of the table.
That's true. That's true.
So you would therefore understand the process in relation to making appointments. Due diligence must be done. There is a cabinet process that must be gone through. You then need to schedule appointments for an exco. That process was followed. They went to the most recent Executive Council, and therefore announcements were made in the normal course of events.
What was the date of the Executive Council meeting?
I'd need to go back and check. I'll take it on notice and get it for you.
Thank you. Did you say most recent? So what's in the last week or so? Was
It would have been, yes,
Yeah,
Senator
yes,
Carr.
So you've mentioned the appointment process. Now, back in 2019, there was an announcement by the government about a merit-based appointments protocol. And I'm wondering, Mr Registrar, if you could tell me, is that still operating?
Yes, it is, Senator.
It is. And that's a process that, from memory serves me correctly, that positions would be determined after seeking expressions of interest, by public advertisement, by assessment of suitable applicants, and by the recommendations going to the Attorney-General. Is that the core of the new protocol?
It is.
I see. So of the 19 appointments, Mr Registrar, how many were subject to public advertisement?
Senator, the process is that we periodically review. There's an annual advertising for the expression of interest register, and we review the expression of interest register and assess suitable candidates, and the President then makes recommendations to the Attorney-General.
So there was an advertisement, was there?
So there was a live register, Senator,
Sorry, no, I just want to
expression
be
of
clear
interest.
about this. There was an advertisement. Was there?
So I think there was an advertisement. I'd have to check when that was, but it might have
Well,
been sometime last year.
Last year there was an advertisement placed, in the Daily Press? Where was this advertisement?
I'll just have to check that, Senator. I might just come back to that
Sure,
question of.
I'd be interested to know.
Mr. Matthews might be. Sorry, Senator. Mr. Matthews might be able to help with that detail.
Thank you very much.
Chris Matthews, Chief Legal Officer. I understand that the register was re-advertised on the 16th and 17th of April 2021.
April. And that was, what was the nature of the advertisement? Have you got a copy of that advertisement?
I don't, Senator. Perhaps the department may be able to assist with that, the actual advertising of the register.
Who's helping us with this?
Alban Smerdell, Assistant Secretary, Legal System Branch, Attorney General's Department. We don't have a copy of the notice to hand, but we can get one
Thank you.
pretty quickly this
If
morning.
you would please, and this, what's the nature of this notice? Is it, can you explain that to me?
I think I'd need to see, it was, as Mr Matthews indicated, it was advertised 16th of April
Yeah, I've got that.
last year. So
I've got that. No, I want to know
I'd
what
want
the
to-
advertisement advised people to do.
I'd want to refresh my memory as to what the notice said before answering that question, Senator.
But what said there was a registrar available if you've got an interest in becoming a member of the AAT? Is it that the sort of thing that?
It would also be seeking applications for various positions, whether it's, I think there might have been a Deputy Division Head position advertised at that time as well, which was a more truncated process, and also inviting applications of a general nature, but also for that particular position.
Right. So there was an advertisement, was there, for the President, the new
Deputy Division Head.
the division head was there? That was back in 21,
Correct.
right? So that's a year ago. There was an advertisement.
Correct.
And were the jobs that were actually announced yesterday, were they a part of that advertisement?
The register is a live register until a new register is called for, so applicants that were on that register would have been considered for the position.
Right. So how many of the 19 were on the register? The 19 appointments yesterday were on the register.
I think we probably need to take that one on notice, Senator.
Sorry, what?
Senator, I think we need to take
Oh,
that
come
one on
on,
notice.
you would, surely you can help me with that. That's not a
Senator-
difficult
Senator
question.
Carr, Senator
How
Carr.
many?
Senator Carr, I'm sorry. Once a witness has taken a question on notice,
Yeah, sure,
could you
sure.
please not reflect adversely on the
No,
witness?
I will
Do you have any other
I
questions?
will reflect that it would be a reasonable question to expect me to ask today how many people were on the register, given that this protocol has been in operation since 2019.
Senator Carr, do you have any other questions?
No, the question is, how quickly can you get that information for us? Is there an officer here that has got that information?
Senator Carr.
Have you got that information at hand?
Chair.
Senator, I can give you a global figure because the Attorney announced more than the 19 new appointments. She also announced a number of extensions and promotions.
Yes,
and
yes.
of the 45 in total that were announced yesterday, 33 were on the EOI register.
Okay, that's a good start because the 19 is the ones I'm particularly interested in. Of the 19, how many were on that
I
register?
think they've taken that on notice.
I know. Well,
for
that's
you.
you can give me a figure of 33 out of the 45 appointments, but you can't tell me how many of the 19 were actually on the register.
Well, we have the global figure, so we'll break that down.
Sure,
and get
thank
that
you.
answer
Would
to
you do that? I'd appreciate if it could be done. Is that easy to do? Is it?
I would imagine so.
Yes. So we could have it within a few minutes, could we? Is it hard to do?
Well, a few minutes might be.
They've actually
Just I
taken
might
it
have
on
other
notice.
questions, you see. I mean, the
Senator
problem
Carr,
is-
do you have any other questions? I'm sorry.
I'm just trying to follow. I have got many
Senator
other
Carr.
questions.
All right,
So-
could you go to your other questions? Please don't reflect adversely on
No,
witnesses.
it's not reflecting at
when
all.
A,
It's
when a
simple
question is taken
proposition.
on notice.
It's a simple proposition. How long would
Any
it
oth-
take you to identify how many of the 19 were on the register?
Senator Carr, the witness has taken the question on notice. It is open to all witnesses to do so. Could you please go to your
Sure.
next question?
I have asked a simple question. How long would it take to identify how many of the 19 announced yesterday, the new appointments, were actually on the register of interest advertised a year ago?
And I think, again, Senator Carr, they have answered that and they said they'd taken on notice.
Yes,
We
and
had
I'm
established
asking how
that.
long would it take to identify those 19?
Well, in taking something on notice, you haven't.
What, you're going to take that on
Yeah,
notice
that's
as well? How long would it
Senator
take?
Carr.
You
Please,
haven't
you're
fully
very
done.
experienced in these
Yes,
matters.
yes,
Please
I
don't.
know, I know.
You know
You're
that
gonna
you
miss
can't
these skills.
reflect.
I can see
I know
the
we are going to miss you
enthusiasm
greatly,
on the other
Senator
side
Carr.
of the table, right?
But you know you can't reflect on witnesses
I'm
once
not
the question's been
reflecting.
taken on
It's a
notice.
simple question. How would that
You-
be
you-
possible?
or even if I can say, badger a witness.
I'm not badgering. Simple question. Simple
I
question.
say that with affection,
How long
Senator
would it
With
take
affection,
you?
Senator Carr, with affection.
All right, Senator Carr,
exactly.
your time is now concluded.
Oh, what a
move.
surprise. What a surprise. But we've been here for quite
we'll-
some time on
That's
this. I
fine,
suspect.
Senator Carr. We will now go to other senators and very happy to come back to you.
In the break, with that 10-minute break, you'll have time to find the answer to my question.
Senator Scarr has the call.
Very generous of you.
Could someone get Senator Carr a cup of tea?
And slip something into it quietly.
Senator Scarr, you have the call.
Yes, if I could just ask the acting registrar, what steps is the AAT taking in terms of addressing the backlog of cases you referred to in your opening statement?
Senator, the recent appointments are always a positive step in terms of assisting us to finalise more matters. The tribunal continues to look at each of the caseloads and nationally the caseloads to identify options and strategies to reduce the backlogs. Each of the individual divisions has its own caseload strategy and undertakes a number of different approaches in order to reduce the backlogs. The
Okay.
primary issue, though, is we welcome those additional appointments to assist.
So the additional appointments that have been made, that's going to make a material difference in terms of addressing the backlog of cases. Is that correct?
Correct. More members, it means more finalisations.
So it is important that, I'm just stating the obvious here, when there are vacancies, it is important that those vacancies are filled as quickly as possible so that backlogs can be addressed and you don't have long periods of time where you've got positions vacant. Is that correct?
That's correct, Senator.
So from your perspective as registrar, you welcome the fact that there have been new appointments made which will assist you to, as registrar, performing your critical role, and I'm a big fan of registrars. I think they perform an essential role across our judicial system. From your perspective, that assists your efforts and the efforts of the tribunal to assist the backlog. Is that correct?
Absolutely, Senator. As I said, we welcome the appointments and more members means more finalisations and the capacity to decrease our ageing cases.
Yep. So there has been the announcement of the new president. From your perspective, I can remember when you last appeared, Mr. Krill, and we were talking about different systems and protocols, etc. And the chair has referred to some of the experiences or reflections of this committee on the past. You made the point, I think, during your last appearance that it would be important for there to be a new president to be onboarded, so the new president could be part of the discussions in terms of what steps and measures should be taken on a more systemic basis in terms of systems and programs. Is that process now being put in train with the announcement of the appointment of the new president? Do you have a roadmap moving forward in terms of catching up with the new president, who's highly experienced, of course, and addressing some of these issues?
Absolutely. We welcomed the appointment of the president last Friday, and it hasn't been a lot of time since the announcement, and the president and myself have had a number of conversations around how we might approach dealing with a number of the issues. But the first issue is bringing the new president up to speed in a very different role than she'd previously occupied. But we are planning to do that over the coming week. And then we will be looking at how we approach all aspects of operations of the tribunal in order to improve access for our users and increase the number of finalisations.
So then, how does that dovetail with the appointment of a new registrar? Does that is that process now going to be progressed, or how is that process progressing? And Mr. Crew, you might not be the right person for me to ask that question of, but I'm just interested in terms of, you've been holding the fort as acting registrar, and that's always a difficult job to perform. But I'm interested in terms of the next steps. Now we have a new president, in terms of the team being completed with a new registrar. Do you have any visibility on that, or is there someone else who can assist me on that question?
I might say, Senator, that the president, the registrar is appointed upon nomination to the attorney, and then it's a matter for the attorney in relation to the appointment of a registrar.
Okay. Is there? You've given some background in your opening statement with respect to the number of applications that have come before the AAT. There was a fall in the number of applications received in 2020-21, primarily as a result of factors relating to the COVID-19 pandemic, but the applications have grown steadily, and you make particular reference to caseload in the NDIS. Is that probably where you're seeing the caseload increase the most? And if so, how do the recent appointments particularly assist in terms of addressing that increase in caseload in the NDIS division?
As a percentage, yes, Senator, that's the largest increase in the tribunal in terms of the caseload, some 300+% increase over previous periods. The recent appointments announced 3 full-time senior members and 1 part-time senior member to the NDIS division, and there were some other appointments in relation to that division. Also, I think there was the appointment of a new division head to that division to replace the outgoing division head, who was Justice Ma.
All right, so from your perspective, you made the point in your opening statement about the significant growth in the NDIS division, but this recent announcement of appointments in particular provides for 3 full-time senior members in the NDIS division and 1 part-time senior member, I think you said, in the NDIS division, and also a replacement for President Ma in the NDIS division. Is that correct?
That's correct, Senator. What it's meant is the opportunity to progress things, including a new practice direction, which is gone for internal consultation this week. So it's another opportunity for people to look at ways in which we can finalise matters more quickly or improve the way applicants experience the process in the division.
So what are the sort of things you consider in a practice division, practice direction, and I assume that's specifically for the NDIS division. So what are the sort of matters that are considered in a practice direction for the NDIS division, and how are they specifically tailored to the NDIS attributes of a case?
So it's early in the process, Senator, for finalisation and consultation on that practice direction. But some of the things that we're looking at is the early triage of matters to identify matters of risk, for example, and ways we can better tailor what's required in those particular cases, so that it's not a one-size-fits-all in relation to the cases within that division. So there's early triage and assessment, outreach, ADR processes as well, and then involving members at an appropriate time in particularly identified matters that might mean those matters are resolved more quickly.
And is one of the things being considered, and this is my final question, and I said earlier in my questions, I'm a big fan of the role of registrars, and I think they can lift the load off the judiciary or members of the AAT in many cases by engaging in that triage and trying to find solutions to cases before they even go to members. Is the role of registrars in the AAT being considered as part of the process of addressing backlog and increasing efficiency?
Yes, Senator. So at the moment, the registrars undertake the alternative dispute resolution processes, and they also do some early case management as well. It should be noted that only a small number of matters in this caseload actually get to a member for hearing. Most of those of the matters do resolve without going to a member because of the work undertaken by conference registrars.
Okay, so well, that's very positive. When you say a small number, is it 10%, 20%? I won't ask you to take it on notice, just a general ballpark figure.
So recently the numbers have been 2% of matters going to hearing, and it's increased slightly, and it's likely to rise with the increase in filings, but we're not sure exactly how far. So somewhere between 2 and 5% of matters going to members for a hearing, but with the assessment of individual matters, then there might be some more matters that go to members earlier, but not necessarily for a hearing.
Okay, well that means, I mean, the corollary of, sorry, I couldn't hear that last bit, but I'll just give you an opportunity maybe to repeat that by just saying the corollary of what you've said is that 95% at least of matters in the NDIS division are being resolved before they even have to go to a hearing with a member. Is that correct?
That's as it currently stands.
Okay,
Yes.
well that strikes me as a really good result, and I commend everyone involved in that process because, from my perspective, that's how the system should work, and you'd hope it would work. No further questions from me, Chair.
Thank you very much, Senator Scarr. Right on time. Senator Carr.
Yes, if I could ask Mr. Crew, the protocols that have been in operation since March 2019 required the President to supply the Attorney-General with an assessment of what positions needed to be filled and at what level, the advice about which members whose terms are expiring, and the President's recommendations whether reappointments should be offered, and the President to provide recommendations regarding suitable candidates for appointment. When was the last time that advice was provided to the Attorney-General by the President of the AAT?
I would have to check the exact date, Senator, but I think Justice Collier provided the last one, so it would be recently, but I'll put it on notice.
Thank you, thank you.
Was Justice Collier as the last one?
Right, so that would have been done within the last 6 months.
Yes, in the last 3 months.
Thank you. And so,
Justice Collier's was acting from the 1st of January.
so how many of the 19 appointments yesterday were on that list provided by the former President of the AAT?
Senator, in terms of the protocol, the process is for the president to provide recommendations to the attorney, and then it's a matter for government as to appoint.
I understand the process. I'm asking a very specific question. How many of the 19 that were appointments that were announced yesterday were on the former president's last recommendation? You said within the last 3 months. How many of those were on that list?
Senator, those recommendations are done on a confidential basis, and it's a matter for the attorney then as to whether those recommendations are taken or not.
Yes,
so it's a matter for
that's a separate question. I've asked you how many of the 19 were on the list.
I'd have to take that on notice, Senator. I haven't looked.
I see. I would have thought if there were many on the list, you would have quickly identified that and to advise the committee.
Chair, we do have the information for Senator Carr in
Thank you.
relation to
Would you
the
do that?
number
Help me
of
with
the
that.
expression of interest. So it was out of the 19, I think you said. The department have advised 13 appointments.
13 were provided by the former president.
Were on the expression of interest register.
No, that's a different question again. That's the question. Thank you.
The question you
I
asked
understand
was on
that.
the
Thank you.
expression of interest
13 of the
register.
19. So there were 6 that were not.
Senator Carr, you seem to have either deliberately or inadvertently not gone through the entire protocol. I'm sure that you are diligently going through clause
I'm
1,
very familiar with the
2,
protocol.
3, 4, 5, 6.
See-
And then you would be aware, Senator Carr, that point 7 clearly states
That's right.
the Attorney-General is not limited to candidates
That's
recommended
right.
by the President of the AAT and may choose to recommend to Cabinet a candidate for a position that has not been suggested by the President of AAT or is not on the register. So again, clearly the protocol at all times has been followed.
I am fully aware of that provision, and
You-
that's
you
where
just seem to have
No,
conveniently
I was
forgot
working through it.
that
I was up at
part of
4,
it.
but you've jumped ahead to 7 to give me.
You just seem to have forgotten that
No,
part of it, Senator
I
Carr.
have not forgotten anything, because I won't exactly go to the number 7. I just was going from 4 before I got there to make sure all the other opportunities were provided. But you basically told me that 6 of the people that you have nominated were on your own advice to the Cabinet.
Well, Senator Carr, those appointments are recommendations to the Cabinet.
Yes,
The Cabinet
yes.
then goes through its own
Yes,
process.
yes.
But if you are saying, I mean, I challenge you to point out which one of those 19 new appointments are not qualified.
Well, let's go through that if you want to raise
15
that. If you've raised
of
that issue.
The 19
Okay.
new appointments, Senator Carr, are legally qualified, including 8 barristers. I would argue that having those legally qualified people is an asset to the AAT, given in particular you are required to have a look at decisions, to have a look at legislation, etc. All of the appointees are highly qualified to undertake the important task of conducting, as you know, what are merits reviews of government decisions.
So, for instance, Michael Mischin, who's appointed to a $496,000 a year position as Deputy President, being a member of the Liberal Party and a former Liberal MLC, was that relevant?
Can I assure you that with Michael Mischin, he is actually a former State Attorney General. He has held the highest legal office in Western Australia. He was admitted to practice as a barrister and solicitor in the High Court and Federal Court of Australia in 1983. He is someone who was a Crown prosecutor. He is someone who has an in-depth understanding of both legislation and the law. He is someone who is adept at understanding factual circumstances and situations presented to him. So yes, Senator Carr, I would say that Michael Mischin, as the former Western Australian Attorney General, as a former Crown prosecutor, and someone who has been admitted now, I think it's around 1982, so what, going on 40 years of legal experience, yes, Senator Carr,
You
he
think
is
that's-
qualified
all right.
to hold
What about-
office
what about
on
Mr.
the AAT.
What about Mr Peter Katsambarnas, another former Liberal MP What is his specific requirements for this job?
Well, again, Mr Katsambanis is actually a former member of the AAT. So as someone who has previously served on the AAT, as someone who also in 1991, I understand, was admitted to practice. In fact, Senator Carr, you might enjoy this. He was actually admitted to practice in your home state of Victoria.
Why would I enjoy that?
Meaning he was a Victorian.
Right, that qualifies him.
But he
I
also
see. I
is,
see.
as a former member of the AAT, as someone who is legally qualified. In fact, I think he was on the AAT from 2003 to 2009. So again, what you have in Mr Katsambanis is someone who is legally qualified, which I think is a very important part of the role, given the nature of what you are doing. He is someone who has already had, a considerable period of time as a member of the Refugee and Migration Review Tribunal. So again, if we were looking at is he qualified or not, I would argue yet again he is highly qualified to again sit as a member of the tribunal. Yes.
Now, and what about Anne Duffield, former Chief of Staff to Scott Morrison? What are her specific skills that she brings to the job?
Yeah, Anne Duffield again is someone who, and you have identified, she has worked in government. So again, she is someone who has an understanding of government, and you and I both know that an understanding of government, I believe, is a very good start. But she has also again served already as a member of the Migration Review Division of the AAT. So again, you have someone who has previously already served, who has an in-depth understanding of the nature of the decisions, the nature of the caseload, and can really hit the ground running. And I think we've already heard from the registrar this morning in terms of the nature of the caseload, etc., and sometimes the pressure that in particular the Migration Division does face. So to have someone who has previously served in this role for a number of years, who has an
So
in-depth...
Anne Duffield, she's a lawyer too, is she?
Anne Duffield is not a lawyer, and obviously it is not a prerequisite.
No.
Certainly 13 out of the 19, I think, was the evidence that I gave, are legally qualified. I'll just ensure that that was the correct... 15 of the 19 appointments are legally qualified, including 8 barristers. But certainly, Senator Carr, in terms of her previous role of being herself a member, she'll hit the ground running in terms of understanding the caseload and undertaking the work that is required.
Thank you, Minister. So Anne Duffield, she was not on the register of expressions of interest. Is that
I
right?
would need to go and check. I'll take that on notice for you.
And there was, of course, Cheryl Cartwright, former Chief of Staff to Warren Truss. What are the qualifications there for your appointment?
I'm just looking. She actually was from 2005 to the 2017. She's highly qualified. She's actually the CEO of the Australian Pipeline and Gas Association.
Right.
So again, someone who is eminently qualified. I mean,
Should be legally qualified as well?
I don't believe she is legally qualified. So, but I would argue that as a CEO of the Australian Pipeline and Gas Association, she is someone who is able to work under pressure. She is someone who is clearly able to make decisions. Given her previous work with government, she is someone who understands the working of governments. She understands legislation. She understands the nature of the decisions that need to be made. So again, I would say eminently qualified for the role.
Was she on the expression of interest register?
I'd need to take that on notice for you, Senator Carr.
What about Prue Goward, the former New South Wales minister? What are her specific qualifications?
Well, in relation
Last question, Senator Carr.
to Prue Goward, I mean, again, I think for her, her qualifications stand for herself, and in particular as someone who from 2001 to 2007 was incredibly well known across Australia.
Oh, it's an ABC reporter.
As the
I'm that
Commonwealth
dreadful outfit,
Sex
Labor
Discrimination.
supporters there,
Well,
the
again,
ABC,
Senator Carr,
yeah.
I think
no way
what
to
it
speak about
shows
the
is
ABC.
that
so are you.
you actually
What
have
about-
people with a number of
Chair was an ABC
qualifications.
reporter as well.
Senator
Oh,
Carr,
God,
I
it's a nest of Liberals at the ABC.
I had
tell you.
nine very
A
fine
nest of
years at
Liberals,
the
I like that,
ABC.
a nest of,
Sorry,
but Senator Carr,
sorry,
again,
Minister.
I think, Ms Goward, eminently qualified.
Oh,
Her
for
record
what?
stands.
Qualified for what?
Senator Carr, we're going to just stop this question. Sorry, we
Can
have
I
gone
just
over your
say, though,
time.
Senator Carr, two people that you have failed to mention, but I am sure you were getting to them.
haven't finished yet.
Obviously was Linda Kirk. Now, you would have served with former Labor Senator
A
Linda
very
Kirk.
effective senator, as well as a highly qualified and effective member of the AA.
Which is actually why she was
So
recently
that's one person with Labor credentials. One
as a
person out of
senior
88 that have been appointed.
member.
88! And you've got one as a Labor person. Well, I'll be...
Well, I would hate
darned.
then
I'll
poor
tell you
old
what.
Mark Bishop, seriously, you mustn't have liked him very
Two.
much.
That's two
Because
so far. Oh,
Mark
keep going.
Bishop, also a former
Two.
Labor senator, was also recently promoted as a
two.
senior member.
Senator Carr, we will need
Senator
to-
Carr, but what I do like what you said is you were very happy to spruik their Labor credentials.
You were the one that raised it.
But you
I just
jumped
wanted
in
to
and
identify
spruiked
it, right?
their Labor
Senator Carr.
credentials. Again, these are two serving members
Two.
who have discharged their duties admirably,
that's true.
and as such, both were promoted
That's right,
recently.
that's
All
very
right,
good.
we will move the call around now to other senators. Thanks, Senator Carr. Senator Van.
Thank you, Chair. I understand that, Mr Crew, that the AAT currently has 318 members. Is that correct?
I think before yesterday,
Sorry.
it was 301.
Okay, thank you. And can you tell us how many of those are female members?
I'd have to take that on notice, Senator,
Okay. Thank
or
you.
maybe I'll come back to you.
Certainly. And going to some...
Perhaps I can assist.
Sorry?
Sorry, Senator Chris Matthews.
Yes, yes,
so-
Mr Matthews.
As at the 28th of March, there were 136 members who were women.
So what's that as a percentage? About 45%, 40, 45%, something like that?
Sorry, I don't have the
That's okay.
calculator in front of me, I'm afraid.
We can do the maths at another
45%, I understand.
Thank you. So would it be fair to say that there are more female members on the AAT than there were in the tribunal, say, a decade ago?
I would have to take that on notice, Senator.
If you would, that would be grateful for that.
I know it's not the AAT, but you may wish to ask that of the courts when they come, because obviously I announced yesterday that for the first time in history on the Division 2 of the Federal Circuit and Family Court, there is now over 50% females as a result of the appointments that the Morrison government has made. It is the first time in Australia's history. So thank you for raising that, Senator Van. I have jumped in there. It is not the AAT, but if you wouldn't mind raising it with the courts, because I think that sends a fantastic message to, in particular, all of those young females out there in the legal profession, that they may one day themselves be sitting on one of the federal courts in Australia.
I had already planned to ask that question.
Thank you. I'm sorry, just
Thanks,
spruiked
Mr.
my...
Dazza.
But it's
Thank you.
I think you should be very proud of, and rightly spruik that
Thank you.
that fact.
Senator, can I just clarify? In relation to a decade ago, there was the amalgamation in 2015-16. So perhaps the best figure we could provide is the number at amalgamation.
That sounds very reasonable. Thanks,
Sure.
Mr Crew.
And Mr Crew, do you agree with former High Court Justice, the Honourable Ian Callanan, AC, that previous experience in a political role is no more a disentitling factor than someone having been a public servant for appointment to the AAT?
I don't. It's not a matter for me to express views on appointments and the merits of an appointment. Senator, what I will say is that people bring different backgrounds, those that are not legally qualified, such as medical experts, etc., accountants, that add value to the process in finalising matters at the tribunal.
So it would be fair to say that members appointed by the government who have a diverse range of skills and expertise is very relevant to the AAT.
We welcome appointments made by government in order to improve the finalisation of matters before the tribunal.
And it's not mandatory that a member holds a legal qualification?
Not under the Act.
And there've been a number of questions about legal qualifications. Can you take the committee through the statutory criteria for appointment as a member?
Pull up the Act, and perhaps I could ask Mr Matthews.
Senator, so the qualifications for appointment as a member of the AAT is set out in Section 7 of the Administrative Appeals Tribunal Act. So a person to be appointed as the President must be a judge of the Federal Court of Australia. A person who is to be appointed as a Deputy President must either be a judge of the Federal Court of Australia or the Federal Circuit and Family Court of Australia Division 1, or be enrolled as a legal practitioner and have been so enrolled for at least 5 years, or, in the opinion of the Governor-General, have special knowledge or skills relevant to the duties of a Deputy President. And the qualifications requirements for senior members and members are similar, so enrolment as a legal practitioner and be enrolled for at least 5 years, or have special knowledge or skills relevant to the duties of a senior member or member.
And just going to something that Senator Carr touched on earlier, as of March 2019, there was a protocol put in place for appointments to the AAT. Is that correct?
That's correct.
Thank you.
Yes.
And just to reinforce something that the attorney mentioned before, the Attorney-General is not limited to candidates recommended by the President of the AAT and may choose to recommend to Cabinet a candidate for a position that has not been suggested by the President of the AAT or is not on the register. Is that correct?
That's item number 7 of the protocol. Correct.
Do I need to table that protocol? Is that
I'm happy
helpful?
for you to, for the benefit of Hansard, perhaps, Chair.
Thank you. I
Thank
will
you very
table
much,
that.
Senator Van.
And just to understand some of the complexity of the work that the AAT does, how many pieces of legislation confer jurisdiction on the AAT?
There's more than 400, Senator.
So it would be fair to say that you would expect that members appointed would possess a diverse range of expertise to assist the AAT to fulfil its functions.
We welcome all of the experience that any appointment brings to finalise matters at the tribunal.
And the statutory criteria aforementioned in Section 7 is consistent with the rationale of ensuring that the AAT has the appropriate mix of expertise to fulfil its functions. Is that correct?
It recognises the diverse nature of the caseloads.
Thank you. And I assume it would be ruled out of order if I asked Senator Carr if he's going to put his name on the expressions of interest register.
No, I can assure you I am not.
That is out of order.
But knowing this
Senator.
minister, I could be appointed anyway.
I will leave it.
That would take the number of appointments to 3 out of 318.
Well,
is
Senator
it?
Carr,
Hang on,
hang on,
Senator Van's now going to ask for all the Labor appointments, and I'm very happy to take that.
I will then take
Would you
you
like
through.
me to take you through?
I was
I
gonna-
how we
hate to
get this.
disappoint you on your final day.
I think I still have the
Raise
call.
the issue.
No, you
What
don't.
can I do?
I'm very happy
That's a good
to,
one.
Senator Van.
Senator Van, sorry, just order. Senator Van, that is a question which is not in order, but given
No,
it is Senator
no.
Carr's last day, I am going to give a little bit of leeway. Senator Carr, I note that you have declined to accept
The invitation to register, that's true.
The invitation,
'Cause-
but you
that's
can
right,
always
that's right.
consider it at a later date.
Because but I
She might
do have
still
a
have
few
the
other
call.
questions.
No, you don't have the call. I'm now going to hand the call over to Senator Carr, sorry.
Thank you. So I was going through a few of these appointments that you've made, Minister, and I'm more than happy to acknowledge the protocol does provide for you to make the recommendations to the Cabinet, and it also to consult with colleagues about potential appointments.
That is correct, Senator Carr.
So I presume you consulted with colleagues about the appointment of Kate Chappell, who's currently working in Minister Payne's office. Is that right?
The protocol was followed as part of the Cabinet process.
Yes. So is
But
it?
can I also just say, because, and Senator Carr, I don't mind if you want to play politics, and that's fine. That's
Fancy
often
that. Fancy that.
people
What
do
a,
politics
you cut
at
me to the
estimates.
quick, you know. You really do.
And I am
With an
more than
election being
happy-
announced today or tomorrow.
I'm more than happy to take you through
I
the
think you're
number
wrong, actually, by
of
the
what
way.
I would argue actually are well-qualified former Labor members of Parliament. They were actually appointed Anna Burke, Linda Kirk, Mark Bishop, John Black, David Cox, Amanda Mendes da Costa, John Rao, Philip Deladakis, Gary Graham, and he's one we could all absolutely agree with. He's currently the ambassador to Ireland and the Holy See. I think we all agree.
Gary Gray was on the AAT as well,
He was
was he?
absolutely
Oh.
outstanding.
No?
These are Labor. But the point being this, Senator Carr, I'm happy for you to play politics. I'm happy for you to throw up mud. But in terms of these people, they are eminently qualified. Please don't demean a woman who is legally qualified, who has been legally qualified since she undertook her articles of clerkship in 1986, as being someone who is not
It's this
fit
Kate Chappell, is it?
for the role.
Is Kate
That
Chappell-
is absolutely correct.
Right. I'm asking a simple
Legally
question. What was the
qualified.
basis for your decisions to appoint?
And I've advised you that the protocol was followed
no.
as per the Cabinet procedure.
And I'm entitled to ask what the basis of, within the protocol, I'm not disputing that you've got the right to make political appointments. That's what the
Chair,
protocol says.
Senator Carr, it does not say that. It says well-qualified appointments.
Oh, well.
And on that basis, as I've stated...
I just don't know how many occasions have occurred where
15
come straight out of a minister's
19
office onto the AAT.
are legally qualified.
How many times has that occurred straight out of a ministerial office
Are you asking me
the
that,
day
sorry?
before the election's announced and onto the AAT? How often has that occurred?
Well, I don't believe... I'm not aware that she is currently working in a minister's office, Senator Carr.
Oh,
She also, I understand,
I see.
worked for Quinton Bryce in Queensland.
oh, right. So,
Does that...
well, I'm just making you consulted with your colleague.
As per the protocol, Senator Carr.
And no, I'm not disputing the fact that's the nature of cabinet government. I understand you talk to people, but you're not aware that she actually worked in the minister's office before you made the appointment?
I did not say that. I said I don't believe she currently
Oh,
works.
I see. So
you have
were
made the
aware.
allegation.
So you were aware that she worked in the minister's office when
I
you
have
made the
people's
appointment?
resumes, Senator Carr. She actually worked on women's policy. I would have thought that is a good thing, an understanding
I
of
see.
women's issues, in particular, given the nature of some of the decisions and some of the situations that will come before you. You would have liked this, Senator Carr. She also worked for the Department of Industry, Innovation and Science.
I'm sure she did a great job there as well.
That's actually
I'm not.
That is a very, very
Is that a
good
qualification for being on the AAT, is it?
Well, again, what I've said to you, Senator Carr, and you can demean people, and in particular women, all you like, but she is legally qualified. She has worked in government. she has worked within departments. To have that understanding, that acute understanding of the way government works, of how to make decisions, understand facts that are presented to you, be able to work through those facts and come to a decision. She actually also was a researcher and writer for the National Domestic and Family Violence Bench Book, which I have to say is something that I know across government we all support, because this is actually, it's an incredible resource, Chair, for those who do sit on the bench. So again, Senator Carr, and I know this is your last estimates and we're having a little bit of fun here, and that's fine.
Well, I'm glad you think this is fun.
But again, I think she was also Ms Bryce's advisor during her entire tenure, during her time as Governor-General. So again, someone who is just eminently qualified for the role.
So the appointment of Fiona Maher.
You mean the new president of the AAT?
Well, the new president, but it'd be very good for us to assist that, if we could, please. Now, I did ask some questions in previous estimates, which weren't, my records suggest to me they're not being answered in full. But so let's go through a few things. She was an ordinary member of the part-time ordinary member of the AAT until November 2018. That's correct, isn't it?
Chair, just by way of perhaps just to ensure that Ms Maher's curriculum vitae is adequately expressed for the record, in terms of her educational and professional qualifications, in 1983 she undertook a Bachelor of Arts at the University of Queensland. In 1987 she undertook a Bachelor of Laws at the University of Queensland. In 1987 she was admitted to practice as a barrister of the Supreme Court of Queensland, and in 1989 she was admitted to practice as a solicitor of the Supreme Court of Queensland and the High Court of Australia.
So she was also promoted from being a part-time member just before the 2019 election. She was promoted to that full-time member at that time. It was 2 years before her term actually expired as a part-time member. That's quite an extraordinary promotion. I'm just wondering, how often does that occur, where a part-time ordinary member has been promoted to a full-time member within that space of time?
Well, we'd have to go across all of the appointments, so I assume the AAT would, I mean, I'm not speaking on their behalf, I wouldn't have that information. They may need to take that on notice for you.
Thank you, if we could. And she was promoted again from this time to the Deputy President's position in December 2020, so that, which is, I think it pays over about $500,000 a year. That's right, isn't it?
Are you talking to me or the AAT?
Yeah, well, AAT,
the AAT,
right?
sorry, the AAT, yes.
Mr. Crew, can you tell me that that's correct? Have I been misinformed on that or not?
That's the total remuneration.
Yeah,
Senator.
but was...
So
Yeah, okay.
includes superannuation.
Yeah, sure. And was Ms Maher appointed to the full-time Deputy President in December 2020?
Yes, 17th of December 2020, yes.
So, then I'll ask you, Minister, can you give this committee your advice as to why the Deputy President Maher was promoted to be President of the AAT only 3 years after she was a part-time member? Did she perform better than anyone else to warrant such a rapid promotion?
She was eminently qualified and the Cabinet determined she was appropriate for the role. If Senator Carr, though, I do recall at the last estimates, you did ask a number of questions. One may also characterise it as character assassination, but that would be a characterisation of what you were undertaking in relation to Ms Maher. I am very happy for the AAT to yet again explain to you what Ms Maher's role was, in particular when she was made the head of a particular division in terms of the work she undertook. Because I think that you seem to have a misunderstanding
Yes.
in terms of what her role was versus what, say, an ordinary member's role is in making decisions.
So, but she managed to leapfrog hundreds of her colleagues at the AOT to secure the promotion. That's true, isn't it?
Well, that's your characterisation. She's eminently qualified for the role, and Cabinet
So
determined
see, it's
that.
put to me, and this is where you can obviously correct my poor understanding of these things, but it's put to me that she completed 29 applications in 2018, 2019. She was paid, what, $295,000 in that year. It's about $10,000 each application. That'd be right, wouldn't it?
Are you talking to myself?
Well,
or
I'll
the
ask.
AOT? Sorry, I don't have that information.
The registrar, if he
Senator
could help me with that. Have I understood that correctly?
So, Senator, following the last estimates appearance, we provided the committee a letter in relation to additional information regarding President Fiona Ma's role and workload. Perhaps I could read out that letter if that assists.
Explain to me where I've misunderstood. This is your opportunity to tell me how I've got that wrong.
We're right on 10 minutes to Senator Carr. So
Yeah,
last
sure, I've got a
question.
few more, you know.
I'll come back to you, that's fine.
Don't worry. Yeah, Mr. Crew, what can you tell me?
So I think, Senator,
Confused by
the
it.
letter that we provided to the committee following that, we set out the total number of case events that had been undertaken, not just the total finalisations.
I see.
Particularly when you move into the NDIS division, noting my previous comments around majority of matters settled through a variety of processes,
Yeah, but
plus the fact.
Okay, but you see, I understand that letter, but you see, in 2019-20, she completed 5 applications, a salary of $329,000 a year, that's $65,000 a case. In 2021, 2 applications in an entire year. That's those figures are correct, aren't they?
It's trying to...
So, Senator, in 1920, she did a total of 103 case events.
Events.
108.
Chair, and again,
Maybe
Senator
three
Carr,
case
I know the point you're trying to make in character assassination. That's fine. We went through this last time. But again, you have an in-depth answer that has been provided to you in AE 22033 that clearly takes you through Ms Ma and the individual cases since the 1st of July 2018 in divisions other than the Migration and Refugee Division. Her work has been in the NDIS Division. It clearly states in this answer, this includes conducting 322 case events comprising 14 substantive hearing days, 256 directions hearings and 52 interlocutory hearings, finalising 461 applications comprising 3 applications finalised by substantive decision, 429 applications finalised by way of consent decisions, 16 applications finalised by way of no jurisdiction decisions, and 13 applications finalised in other ways. It then goes on to say the following, and this is very important because it is the NDIS division chair, and you'd be aware that depending on the division you're in, the way you actually go through a case, the way you work through with the parties can be quite different. So it clearly states this: the NDIS division caseload relies on a significant amount of pre-hearing work to manage and finalise cases. Many NDIS cases resolved by consent, often as a result of alternative dispute resolution processes, mostly conducted by registrars or by interlocutory or case management hearings conducted by members. So, Senator Carr, you have in front of you the relevant answer to your question. So to deliberately now today try and muddy the waters because you don't like the appointment, I think is a little unfortunate on your behalf.
Senator Carr, we will need to move to other senators.
Thank you.
Happy to come
We'll
back to you.
it, yes.
Look, I just wanted to ask a couple of questions about the respective workloads of different members of the AAT. Minister, perhaps...
I think the registrar perhaps, I've read out some of what it is, but the registrar is probably in a better position to explain the different workloads, etc.
Mr Crew, can you just go through the different roles within the AAT from the President down and explain, I guess, the more complex role of positions such as the Deputy President and the divisional heads, please?
Might pass to Mr Matthews, Senator, if that's okay.
Sure, Mr Matthews.
So, Senator, the President has the overall responsibility for the management of the Tribunal, and that's set out in Section 18, capital A of the AAT Act, and that is responsible for ensuring the expeditious and efficient discharge of the business of the Tribunal, and that the Tribunal pursues the objective, the statutory objective in Section 2, capital A. The President is then assisted by the division heads, and the role of the division heads is set out in Section 17, capital K of the Administrative Appeals Tribunal Act. And the head of a division has the function of assisting the President in the performance of the President's function by directing the business of the Tribunal in that division. So the division heads are responsible for the various aspects of ensuring that the caseload in their respective division is managed effectively and efficiently. So that's in relating to the way in which the cases are dealt with, as well as the members who are dealing with the caseload and the registrars who assist in the management of the caseload.
And how are the cases allocated? Do you have that information?
I think they do.
I mean, in a very so the way in which cases are allocated, will vary across divisions. And that will also then relate somewhat to the kind of size of the caseload. So the division head, for example, in the Migration and Refugee Division is assisted by a caseload strategy section. So consistent with the caseload strategy, cases are allocated to members based on the caseload strategy and the availability and the skills and experience of the different members. But that would broadly also be true of the other divisions. But the division heads are responsible and for overseeing the allocation of cases to the membership.
So just going back to the role of the divisional heads, they have a very significant role in the administration of their particular division. So they don't just sit on cases, there's a lot more to the job, in other words.
That's correct, Senator.
All right, thank you very much. I will now hand over. Senator Carr, are you seeking the call again? Could I make you a cup of tea in the meantime?
No, I've already got a cup of tea.
All right, I want to really look after Senator.
It's whether or not it's got something
the
extra.
beauty of you
extra.
actually doing the filibustering is it gives me a chance to rearm.
And to have
That's
some-
a
and have
joy.
some morning tea.
So you admit it, you're rearming, you went outside and took
I have,
instructions.
because you see,
I
what's
saw
happening
you.
is- See, what happens here is that, this might shock you,
Who's
Minister,
giving you
but
instructions,
there is a
Senator
public
Carr?
interest in our proceedings, and as a consequence, people actually send me messages.
Is that the Shadow Minister?
Had to be
Is that the Shadow Minister?
Could we table that? Could we table that message?
I'll get to that in a minute, because you see,
Could we table
what
that?
happens is that people are concerned about the AAT, as I am, about it being so heavily politicised that it actually lacks the authority that's so necessary for a vital organisation in terms of the way in which the government, people are entitled to take a deep interest in the administration of the AAT.
Senator Carr, do you have a question?
So I'm just saying that
Give Mark our best regards.
I had, Justice Marr, can I just be clear about this? She's spent 5 years as a solicitor at a range of legal firms. Can you indicate to us, given the government, this is a government appointment, what are the range of legal firms? Do you know that?
I have Ms Marr's curriculum vitae in front of me. I'm happy to say I can start in 1985. She was an associate to the Honourable Justice D.M. Campbell in the Supreme Court of Queensland. You would be aware, Senator Carr, that those positions are few and far between and are actually sought after by many. But Ms Marr was an associate to the Honourable Mr Justice D.M. Campbell in the Supreme Court of Queensland. In 1986, she was a law clerk at Morris, Fletcher and Cross. In 1987, she was again deemed good enough to be an associate to the Honourable Justice De Jersey of the Supreme Court of Queensland. From 1988 to 1993, she was a solicitor at Flower and Hart, Garland, Hawthorn, Bra, Carter, Newell, Morris, Fletcher and Cross. In 1993 to 1997, she was actually Group General Counsel and Company Secretary, Telecom New Zealand, Australia. I'm just jumping at 1997 to 2000. She was the Queensland Manager of Legal Management Consulting Practice Group Professional Development at Blake, Dawson, Waldron. 2001 to 2004, she was the Professional Development Manager, Change Manager and the Chief Operating Officer at McCulloch Robertson. 2004 to 2014, she was a management consultant in a private capacity. From June 2017 to November 2018, she sat on the Mental Health Review Tribunal in Queensland. In 2014 to 20, she was a member and presidential delegate. 2015 to 2018, I think we've established she was on the Administrative Appeals Tribunal. So without a doubt, she has an extensive legal career.
Okay, so going from what you've just read out, it would appear that she hasn't actually practiced law, that is, as a lawyer, since 1997. Is that correct?
Well, you'd need. She is legally qualified, and I'm assuming a number of those roles would require, obviously, legal qualifications. I mean, once you're a lawyer, you are a lawyer,
right.
Senator Carr.
So, in fact, she was a management consultant for the longest period of that list you've read out. That's from 2004 to 2014. So it's been 25 years since she actually worked as a lawyer.
Well, I would assume that Senator Carr, in her role on the Administrative Appeals Tribunal, she utilises her legal skills every day.
I'm just wondering, has there ever been an appointment to the federal court with such limited experience as an actual lawyer practicing law?
She's doing an outstanding job, and again, Senator Carr, the mere fact that you do not like the appointment
that's not a question.
of someone who is eminently qualified for this role, in particular given she is someone who was already in the system, in particular given that I have made a commitment that as part of the Morrison government I will look for an outstanding woman, and I found one. I was absolutely delighted that Cabinet agreed to this appointment.
Well, it's very unusual for a minister's recommendations to actually be rejected by the Cabinet. I would have thought that'd be the pattern. You've never had any of your recommendations?
It's part of the Cabinet process.
I
You know that I could never talk about that,
but
Senator Carr.
You know as
but I
well
will
as I
take
do
yours.
what the
If there's another
consequences of
Cabinet,
you-
I'll take your potential nomination to the AAT and I'll let you know.
Right, that's right. I can imagine the conversation.
Or the Fair Work Commission.
Excuse me.
Or the Fair Work Commission.
Minister Cash, you'd have to win an election to do that, and we look forward to that little hurdle being addressed when the announcement's made today or tomorrow. But let's have a
still
look.
undefined
Let's have a look.
benefits.
I'm going to give
Now,
you.
there were some questions you've raised
Can we
about.
take $100 on calling the election, Senator Carr?
We don't bet in the Senate, as you well know. It's
I
probably.
think you're. I
I think you're punting pretty hard right now.
I think you're wrong, and I'll take the $100.
That's right. Okay, so I indicated before that Ms Maher's record, and you've said to me that I've misunderstood it. So could I ask for a detailed breakdown of all the directions hearings heard by each of the senior members and each of the deputy presidents of the tribunal in 2019-20 and 2021 financial years?
I think the AAT would have to take that on.
Of course they would.
Yeah, I'd take that on notice.
Accept that.
Yeah.
And I'll ask if you're able to tell me does that provide, does this provide an accurate comparison between both senior and deputy presidents in those years? That's a second question.
The
I'd ask
AIT have indicated they'll
to
take
answer
on
that
notice.
on notice, because
Yep.
you'll obviously need to double check
They'll
that
need to
this
go
time.
back.
And I think that's the case. So Donald Morris, he previously, can you tell me, Mr. Donald Morris's qualification for the extension? He was a former senior advisor to Senator Betts, wasn't he?
I will just have a look for you. He has been a member of the AAT, I understand, since 2016. In 1993 to 96, he was actually Secretary to the Government of Norfolk Island. So again, someone who has extensive understanding of government and how it works, but he has already been a member of the AAT for going on 16, 17, 18, 19, 20, 21, 6 years.
Right.
He's been a member of the AAT.
Thank you. Can I just, Mr. Registrar, could I go back to the statement that you've made in your opening address? You said there'd been a small decrease in the AAT's overall base appropriation, and that
Yes.
announced in the budget. You said that addressing our large and ageing backlog within existing resources constraints represents a significant challenge for the AAT in 2022, 23 and the forward years. Can you enlarge on that statement?
So, Senator, the small reduction was from 162.5 million to 158.5 million in terms of total appropriation. So it's a small reduction. The ageing caseload and with respect with Senator, that was before the announcement of the additional 19 appointments as well. In terms of our opportunity now to address some of those ageing cases with more appointments. But again, we will continue to work with government in relation to the funding that's required, but we'll have to prioritise where our spending occurs.
And so how will you meet that new criterion? You say reprioritise. What will the change be within the organisation to meet that new budgetary constraint?
Well, the new president and hopefully soon to be registrar will obviously undertake an appropriate strategy based on the information available and target the areas of spending that need to be prioritised. We will look at all avenues to focus on our core business of and undertaking merits decisions.
Minister, can you explain why the government's reduced the base appropriation?
I can get the relevant officer to come to the table for you and explain it.
Senator, Ms Harvey will be able to assist on this one.
Tamsin Harvey, Acting Deputy Secretary, Legal Services and Families Group. As I understand this, Senator, some of the change relates to, there's a couple of different factors. One of them is around the efficiency dividend and one being around variations in funding for the Social Security and Migration divisions, in part to do with some of the funding that's provided for the Immigration Assessment Authority each year.
So, Mr Crowe, you've indicated that you want to engage with the government regarding our ongoing resourcing needs. How much short are you?
So we're continuing conversations, Senator, with the Attorney General's Department in relation to funding measures and opportunities. We will look to prioritise and work with the new President and new Registrar in targeting what funds we have, the services that we need.
Senator Carr, we are now at the conclusion of your block of questions. happy to come back to you. Minister, I just wanted to go back to the appointment of the Honourable Justice Fiona Maher as
Yes.
President of the Administrative Appeals Tribunal,
Yes.
and I just want to put on record my very strong support and congratulations for...
Thank you. For a strong woman
the
now being
government's
appointed both
recognition of
as
it.
a judge of the Federal Court of Australia and the President.
Of an
Thank you,
exceptional
Chair.
woman, highly qualified to lead the AAT. I note Senator Carr's criticism in relation to Judge Maher's legal practice, but when I look at her CV and look at the extensive combination of both practical legal practice but also administrative practice.
Absolutely.
One of the core concerns
Yes.
that we have
Yes.
raised, and including Senator Carr,
Correct, is the administration.
consistently is
Correct.
the issues with the administration,
Yes.
the internal administration
Correct.
of the AAT. And I will put on record that I do believe previously at the top that was somewhat lacking, and I am delighted to see someone leading the AAT with a combination of the strongest possible skills, both in legal practice and in legal administration.
And I would also say there,
And so
Chair,
the
as
question
a
is-
Chief
so
Operating Officer, you bring a skill set that is highly desirable to the AAT in that role.
So just pulling myself up in terms of asking a question. So why is that combination of skills, both in legal practice and legal administration, so important for this role?
Yeah, because Senator Carr approaches the role as if it is one that is analogous to merely being a member. And I shouldn't say merely, being a member who is presented with a case and who gets to determine that case, the role of a member. As you would know, the President of the AAT actually leads the AAT. It is not necessarily about the cases for the President. It is about the administration of the AAT across all of the different areas. And as such, merely having the ability to make a decision, Senator Carr, is not necessarily the relevant skill set, is a broad range of skills, in particular when it comes to the administration of the AAT and how it functions and how it works, that is so important. And hence, when you look at Ms Maher's resume, you can see that she has that broad range of skills that complements the role that she is now in, but also the fact that she has been a member, the fact that she has been a deputy president and a division head. She has a unique understanding of how the AAT itself works, what actually needs to be done to ensure that it operates as efficiently as possible. She obviously has the legal skill set which is required, but at that same time, in terms of, for example, her time as a chief operating officer, even sitting on other tribunals, she brings a wide-ranging skill set that is appropriate for the role.
So obviously the President of the AAT has worked not just as a solicitor, but also as a management consultant, a chief operating officer, group general counsel.
A company secretary.
Company secretary.
Yes.
Worked as a member of the Mental Health Review Tribunal, a senior member of the AAT, a deputy president and division head. So I would say and congratulate you,
Thank
Minister,
you.
for an excellent
Thank
appointment.
you.
And I am looking forward to seeing significant improvements in the AAT's administration.
Thank you.
With such strong leadership in the appointment of Judge Maher.
Thank you, Chair.
On that note, I will now hand over to Senator Grogan, who has some questions.
Thank you. I'd like to talk about the Human Rights Commission.
Are we dismissing the AAT? Because we've got to call them on.
Dismiss the AAT yet.
Okay.
So
what
we need to
might-
call them on for you.
Yes. So Senator Grogan, if senators have no further
we're done
questions.
with the yeah.
So if senators have no further questions for the AAT,
Thank you.
We will dismiss officers from the AAT. We thank you very much for your evidence and for your time this morning. We are now going to have a small break.
Just to bring on the... Are they here in
No
person,
morning tea.
Chair?
We have
morning tea.
we have a 15-minute break and then we will be going to the Human Rights Commission after the break. We will resume
Thank you, Chair.
in 15 minutes.
The Human Rights Commission,
The
okay.
committee is
Chair.
suspended. The committee is now in session, and I would like to welcome officers from the Australian Human Rights Commission. Professor, good morning. Do you have an opening statement before we go to questions?
Thank you, Chair. For Hansard, Emeritus Professor Rosalind Croucher, President, Australian Human Rights Commission. By way of brief opening comments, Chair, if I may, as the focus of this committee is on budget matters, and as the annual report for the Commission and the portfolio budget statements are published, they show that the Commission has indeed faced significant budget challenges which came to a head last year. Chair, before going to questions, I did want to warmly acknowledge the role of the Attorney-General and her department in providing an equity injection of $16 million to enable the Commission to meet its financial obligations this financial year. And the agreement of the Attorney and the Prime Minister to consider an appropriate level of ongoing annual funding in the MyEFO process. I also wish to acknowledge the support of government for a range of specific project funding, which speaks to the value of an independent national human rights institution, both nationally and internationally, and also to the work of the individual commissioners of the Commission. The Commission is committed to continue working with the Attorney, with the Department and the Department of Finance to ensure we are adequately and reliably resourced to deliver our statutory obligations into the future. By way of two closing observations, I would also warmly welcome the reappointment of June Oscar as Aboriginal and Torres Strait Islander Social Justice Commissioner for another 2 years, to continue her key leadership in relation to Indigenous women and girls in her Wiyanuyu project, Women and Girls. And finally, I would also like to note, as this is Senator Carr's final estimates appearance, I would also like to wish you well on behalf of the Commission in the next steps in your career, and thank you from a personal level for your probing questions over my 15 years in this hearing context. Thank you, Senator Carr.
Thank you very much. Very nice of you. Thank you.
Thank you, Chair. My colleagues and I are all present today on video link or in person, and we welcome any questions that the committee would like to put to us.
Professor, thank you very much. I'm just going to start off with some questions focused on your budget, and you raised some concerns about that, and including obviously acknowledging the $16 million equity investment by the government. I just wanted to understand the budgetary issues, and I guess looking at the increased budget allocation the Human Rights Commission has received. So if I look at the amount of money the Human Rights Commission has received since 2013-14, it's a 22% increase since then. So obviously a very substantial increase over that period of time. Could you perhaps explain why there are these financial issues and whether there have been any concerns raised about the Human Rights Commission's own financial record keeping or any other internal matters in relation to the way in which you manage your own budget?
Yes, Senator, I welcome that question. Chair, there are two separate issues in relation to your question. One is the government resourcing of the Commission, and the other is an internal issue. With respect to the internal issue, if I may, yes, we identified some issues in our financial management. They came to a head in June last year, and with the cooperation of a tripartite steering committee involving the Department, the Attorney-General's Department, Department of Finance and the Commission as well, there's been work to ensure that our financial management internally is in good order. The ANAO also made a finding and some recommendations which were in line with actions we had already instigated. There is indeed an internal management issue, and it led essentially to this proposition that we overspent the budget that we were given by government in our appropriation on employee expenses. That's the internal issue. The external issue goes to...
Well, just on that internal issue, so just to look at the steering committee, which was presumably set up after review of the Human Rights Commission's management of internal finances and operations, what were some of the key findings which led to the establishment of this steering committee?
The need for better tracking. Our financial management system was not fit for the purposes that we needed it to deliver. The cash forecasting was inadequate, and that led to some of the issues internally.
Sorry, President, you're raising some very serious issues here about the Commission's competence in managing its own budget, including basic forecasting. You must be pretty concerned that it's got to this.
I am very concerned, and the action we've taken from June last year when this issue came directly to the attention of myself and commissioners, the action that we have taken has been strong financial management to ensure that this doesn't happen again.
Right. So when you say it only came to your attention last June, that's to me of a concern in itself. Why weren't you, as President, across this financial mismanagement within the Commission?
Indeed, I accept as the ultimate authority, as the accountable authority, the buck does indeed stop with me. I have acknowledged that in the public papers of the Commission and to my Commissioner colleagues and to all the staff. The Commission works...
So what sort of blowouts are we talking about, which, as a result of some of these mismanagement issues?
The over-expenditure on employee expenses is the key issue. That is, we spent more on staff than we had, and that led to a running down of the cash, which produced a situation in June last year that needed completely addressing on so many levels.
So can I just, sorry, President, can I just go to this point? These are issues of basic financial management. Were you not tracking your spending appropriately? Because any comprehensive, continuous forecasting of expenditure would pick these issues up on an ongoing basis. It just seems absolutely shocking to me that they sort of only were identified by you last June.
I agree. They should have been picked up before that and addressed earlier. We have undertaken intense review internally of the issues. We have been supported by the department in coming to grips with how the issues arose, and I fully accept that if we had been tracking our cash forecast better, and one might say appropriately, then we would have been much more sharply aware prior to June last year. It came to a head in June last year. There are a number of threads behind it, but I think just to keep my answer to you brief, the issues were identified clearly by that time. They had been emerging in that few months beforehand. We have addressed the issue of the staff responsibilities and also the systems responsibilities. And I'm sure that going forward with the much greater integrity internally with our processes, now with an external audit and risk committee, as all agencies have now, that the various components that led to the situation that required the assistance of the equity injection, which I have warmly acknowledged, the circumstances may not have led to that. But there is an additional component.
President, I just want to raise one really important issue. We've talked about this equity injection, and it seems to me that it was needed because perhaps of this financial mismanagement. and the blowouts in your own budget through this mismanagement. Why weren't these issues canvassed with the committee when we asked about your budget management at the last estimates? I'm concerned that you weren't transparent about these matters when you last came before our committee.
Thank you, Chair. When I came before the committee last time, the annual report had not been published. I was not.
No, but you were aware. You were aware of these issues since last June, and we did talk about the issues with the need for the $16 million equity injection, and none of these issues were raised with our committee. And I do put to you very strongly that I am concerned that you weren't transparent when you last appeared before us.
Chair, I answered directly the questions I was asked. There is no obfuscation in any of my answers to the committee. If the annual report had been published by that stage, had been tabled, I would have spoken to it then. But as the annual report was not tabled until after my appearance, the appearance of the Commission at the last Estimates Committee, I was not asked about it. Had the annual report been tabled, I would have spoken as I am speaking now, with the annual report tabled, with the...
But you're not a mouthpiece for the annual report, you are the President. So when we ask questions about budget, I would expect a fulsome answer. Can I just go, and I know I need to go to Labor senators, but very quickly, and I will come back on these matters. Does the Commission's actual expenditure match its portfolio budget statement estimates? So, in other words, has the Commission been able to appropriately budget for the future? Because I'm now concerned that the forecast in the budget estimates may not be accurate because of the Commission's failure to stick to its budget, in other words.
Thank you, Chair. I would like to answer that question in terms of the future. In terms of the prior failings, I have confidence that we have addressed those, not just by our own eyes, but with close cooperation with the department to ensure that our systems are now, and our personnel are the key people in the mix of financial management, that we won't err again. I fully accept your observations.
So you do accept ultimate responsibility for this mismanagement?
Absolutely. The buck stops with me as accountable authority. But may I answer the second part of your question, please, which goes to the forward issues? While we overspent on our employee expenses, I completely accept that, which is the element that we should have identified and we didn't. However, going forward, we now have, because of the integrity and forensic analysis that we have done ourselves with the Cooperation Department of Finance and the Attorney General's Department, we have a very good picture as to what our budget components are. Going forward, and you referred to an historic thing from 2014 and an increase over that time. What is crucial to appreciate in our budget structure is that the government funding for us has two key components in it. One is the underlying resourcing of our appropriation, which has sat around the 16.5 million mark over that time and is projected going forward to be around that mark.
Look, I'm just conscious that I do need to share the call around.
I
just
agree,
one
but
final...
Chair, may I please answer the second part of the question? The additional
briefly,
component in our funding, which I referred to in my opening statement, goes to the additional specific project funding that is given to the Commission, particularly for the work of individual commissioners, on a project-specific basis with limited time in it.
Look, I'm sure the committee will explore that further. Just one final question before I go to Senator Grogan. Why precisely was the steering committee established?
In order to assist us in determining the steps that led to the financial issues and to ensure that we could determine what was A, financially affordable, and B, functionally sustainable. They are two different issues.
So the steering committee was established after it was identified that there'd been these financial mismanagement issues?
Yes, to assist us to work through to reach what was a financially affordable model that is within the basic appropriation of $16.5 million and what is functional sustainability. And that is where the door has been opened by the Attorney herself and backed by the Prime Minister to bring a case to MyEFO as to what is an appropriate funding base
I don't think that
going
MyEFO deals with financial mismanagement issues. Clearly, what I'm asking about...
Yes, it does.
What I'm asking about is the steering committee, so in relation to the review of the Commission's finances and operations, could you just, I'm conscious of time, very quickly identify what were the key outcomes of the findings of the review into the mismanagement of your finances?
I think they're reflected well in the ANAO finding, which indicates the basis on which we, the things we need to make sure that we have in place. The ANAO, if I may, noted the operating deficits, the sequence of operating deficits, which is the issue that led to the depletion of our cash. The ANAO recommended that we review the design and effectiveness of our key financial management and budgetary controls, including clarifying the roles, responsibilities and accountabilities of the key personnel involved in the Commission's budget management process, improving the effectiveness of the Commission's budget management process, including establishing budgeting reporting standards and thresholds, and strengthening budget monitoring mechanisms. All of those...
They're all
in train.
They're all the improvements that have been recommended.
And they're all in train.
But what were the deficiencies? Could you just briefly outline those for the committee? I mean, you've talked about over-expenditure and lack of forecasting and lack of tracking. Were there any other deficiencies that you could share with us?
In terms of internal management issues, perhaps the single component is a failure to set a budget properly to operate within.
Right. Well, that's obviously a very serious issue. On that note, I'll hand over to Senator Grogan.
Thank you, Chair. Professor Croucher, obviously you've done a lot of work to turn this around. Is there anything else you'd like to put on the record regarding this issue? I know you didn't get to fully answer some of those questions. Is there anything else that you would like to add?
Yes, I introduced the idea in my response to the Chair about the work that we've been doing in this steering committee towards unravelling what is a financially affordable model and a functionally sustainable model. Through the work of that committee, it's been identified that a financially affordable staffing level for the Human Rights Commission sits at around 76 staff. We have an ASL cap of 116, but we can't afford on responsible financial affordability. We in fact need to have a staffing level of only 76. But a functionally sustainable model, which also is under discussion through that excellent work of the Tripart Steering Committee, sits at double that in terms of the wide range of the remits of the 8 statutory office holders, myself included, and the work across the various pieces of legislation. So what the process has enabled, that I spoke about in answer to the questions to the Chair, is a much greater understanding of what a functionally sustainable commission might look like. And we have the opportunity to have those conversations through this well-established committee in the coming months.
So would you say that part of your financial challenges to date have been brought about by a contradiction between the number of staff required to fulfil the obligations of the Commission, much of your work being held in legislation, versus the amount of money that is actually appropriated to the Human Rights Commission to undertake that work?
Senator, in my response to the Chair, I identified the 2 key components, our basic appropriation and the project funding. And the project funding has enabled the overall resources of the Commission to be enhanced. However, that is not about the Commission having the resources in the first place to decide what our program of work might be as an independent national human rights institution. So while we have been successful and the individual commissioners have essentially, through, as they describe it, fundraising, have enabled additional resources to be attracted, they are for specific projects and don't go to some of the core functions of the Commission, like complaints handling and our other work. So it is certainly true that government has provided that level of funding, and indeed when an important piece of work like the Commonwealth Parliamentary Workplace Review was to be undertaken, it was to the Commission, with the integrity and the standing that the Commission can bring into an inquiry like that, that we were asked to do that. But so putting that aside, the components of our budget, if you take off all of the additional material, what you have at its base is an ongoing funding of around the 16.5 million, and we have identified already that financially all the staff we can afford is really at a much reduced level. We are in ongoing discussions about this, and I welcome those. The exposure of the detail that we have necessarily gone into at so many levels, having recognised and acknowledged the issue that led to it, essentially by hiring the staff we needed, but without the funding base to provide for it. So it's a structural issue that we have unpacked fully now, and that really has been as a result, sadly, of a financial crisis, but as a result of that, we have identified clearly what the underlying parameters are, where we need to have the conversations going forward to ensure that we can, as a national human rights institution, be an independent body.
But part of the issue here potentially is that you have insufficient money to undertake your core functions, understanding that additional money is provided for projects and various other issues that the commissioners are undertaking. But the core functions of the commissioners and of the Commission, the resourcing for that is insufficient.
Yes. And the modelling that we have done in conjunction with the department and the tripartite committee is showing the extent to which it is deficient.
Well, that's a good thing, obviously.
Yes. One hopes that this crisis that we've navigated has a silver lining, and it's been a much greater understanding of the dynamics in play, both internally and in terms of our functions overall.
Can I just follow up on that question, if I could? Are you telling this committee that you're not funded to meet your statutory obligations?
Not funded to adequately discharge our functions.
That's a different question. It's a different question. If an agency comes to the minister and says, listen, we don't have sufficient resource to meet our statutory obligations, that's a very different category of problem for a minister and a government. So can I ask you again, are you funded to meet your statutory obligations?
I think the answer I gave is an appropriate one. That is, we are funded insufficiently to do the full range of functions, and if we are going to work
President,
to the...
sorry, you do need to answer Senator Carr's question.
We can discharge our functions to a very minimal level. So my comment in response, which was to adequacy, I think is the accurate one. Mm-hmm. The consequence, though, Senator, if I may, is that there is a huge difference between discharging our functions at a minimal level and being able to make independent decisions about a program of work of myself and 7 statutory office holders, together with maintaining a complaints handling function. And some may say, well, look, just let the backlog blow out. But with respect, I don't think that is an answer at all, because the ability to provide the conciliation and otherwise, I heard the evidence of the attorney in relation to the Administrative Appeals Tribunal testifying to the value of the processes that precede a hearing. Well, the work of the Australian Human Rights Commission in the complaint handling section is all in that domain, and our inability to provide advice to business and to assist people to a reasonably concluded process is fundamental to access to justice and to relieve a burden on courts. It's enormously helpful to business and the community in terms of the guidance work and otherwise that we deliver. So there's a big difference, Senator, between being able to say, hand on heart, can we discharge our functions? Well, maybe, but with respect, that is not the appropriate answer. The appropriate answer is, if we're going to be a fully functioning, independent national human rights institution, then it is inadequate for that.
Thank you.
Thanks, Senator Carr. I'll now move to other senators and give the call to Senator Scarr.
Thank you, Chair and President. Congratulations on much of the work that the Human Rights Commission has done during the course of the year. I always find the published reports and the work done to be extremely useful and informative, and congratulate everyone involved. I must say I was surprised by the discussion we've had in relation to financial management, and just to give you some background, I'm an old company secretary and general counsel of a ASX listed company, which was subject to all the continuous disclosure rules and the potential for class action litigation. So it's probably in my DNA to look carefully at annual reports and disclosures to ascertain whether or not they're fair and appropriate. And I must say, Professor, I've just had a look at this now, this issue that's arisen. And I've looked at your overview contained in the annual report that's just been released. Do you think that overview, on reflection, provides a reasonable summation of the issues which you've just outlined to this committee in terms of what you referred to as, I think, using your words, as a financial crisis almost that the Commission faced at the end of last year? Do you think your overview of 5 pages, which I've quickly just read, gives an adequate representation of that to the broader Australian community, including the taxpayers of Australia who fund your organisation, but also all the stakeholders who have an interest? All Australians have an interest in having a sustainable Human Rights Commission to discharge its statutory obligations. I'd just like you to reflect on that question, please.
Thank you, Senator, and it's an entirely fair question. I have a little bit of it here. I don't have the full 5 pages. The text in the annual report does address the fact that we've been operating beyond our annual funding resources, which I've expressed in language to this committee in response to direct questions from the chair. It was a crisis, and it was a crisis for me as accountable authority, not having recognised this. It was a crisis that needed immediate resolution in terms of our responsibility in managing our budget to this government and to the wider community. The text in the report describes in the flat way that text is required in those contexts of the parameters of the issues. I've described it in more adjectival language perhaps today, but I thought the circumstances required it, and in light of the fact that our annual report wasn't before this committee at the time of the last hearing, that it was appropriate to refer to it in that way.
President, can I put it to you, and I've given you the context of my professional experience I bring to this place, that if an organisation is faced with a financial crisis of the type you discussed, that needs to be front and centre of any annual report or other report which is made by that organisation with respect to its activities. And I note, and as I said, I've caught it up on my phone. My eyesight's not terrific, but I'll do my best to read the paragraph. And I just ask you to reflect as I read this paragraph whether or not there is appropriate alignment between this paragraph and the commentary which you've provided during the last half hour. And this is on page 5 of your annual review. So we have to get to page 5 of the annual review before this paragraph appears. As we move forward, the Commission is facing certain financial issues. The Commission has been operating beyond its annual funding sources. This is in part a result of cost pressures faced by the Commission, including the costs associated with supporting commissioners and an increase in complaints over the past 5 years. In addition, the work of the Commission has increased substantially because of the COVID-19 pandemic, with the Commission recording a 35% increase in complaints this year, and this trend is continuing with current projections estimating over 4,500 complaints in the next reporting cycle. The Commission is working with the government to address these issues in a way that ensures that the Commission can meet our statutory obligations in promoting and protecting human rights in Australia." End quote. The things that leap out to me from reading that paragraph are first that it's contained on page 5 of a 5-page overview. That's the first point. The second point, it says it refers to certain financial issues, end quote, rather than putting in stark relief what the actual issue was. And third, and perhaps this is the issue where you might be able to provide the most commentary, it doesn't refer to any issue at all in terms of the internal processes, financial management processes of the Human Rights Commission. It's as if these are things outside of its control and not things which are within the province of, again, as I say, as an old company secretary and general counsel, which go to the core of, say, in that context, director duties in terms of being able to trade, remain solvent and keep paying your debts as and when they become due and liable, in particular employee expenses. Can you see how when I read that paragraph, page 5 of your overview, and try and marry it up with the commentary you've just provided, there's a disconnect?
Thank you, Senator. The ANAO financial report is the core of the report, and it's very explicit as to the particulars of the problems. In my statement, look, I'll be guided by you and your experience, to which I defer, and perhaps my text, if there is an issue of this kind, will be more explicit. At the time, we were still working through the certain financial issues to which I referred in using that language. The ANAO findings are quite clear, and that is what we've been working on. I can't change the text of my report now, and I certainly recognise the experience that you shared with me. My experience is not that. But I will. I have learned much through this process, I should say, Senator, and the report as a whole, the ANAO findings, I think, give you the complete picture.
But President, again, this is the issue. Should I have to get to page 85 of the annual report, and it's page 85 in terms of the ANAO report to read, and I'll read it. Again, I've got to take my glasses off. Material uncertainty relating to going concern. I draw attention to the going concern note in the overview section of the financial statements, which indicates that there is material uncertainty as to whether the Commission will be able to establish a sustainable funding model, and therefore whether it will be able to realise its assets and settle its liabilities in the ordinary course of business and at the amount stated in the financial statements. These events or conditions, together with the other matters set forth in the overview, indicate that a material uncertainty exists that may cast significant doubt on the Commission's ability to continue as a going concern. End quote. Why do I have to get to page 85 of the annual report to see such and I could tell you in a listed public company environment, that's a company killer, to see such a statement made with respect to the financial sustainability of the Commission. Why wasn't that specifically dealt with in your overview? Because there's no suggestion of that when you actually look at your overview.
Thank you, Senator. Well, it's obviously not clear enough in this context for you, and I respect your experience
Well, it's
there.
not. Sorry, President. It's not about me. It's not about deferring to my past experience, whatever. It's about making sure that every government agency provides a fair and reasonable view with respect to its accounts, with respect to its financial status, so the public and all stakeholders are able to assess its position on whether or not action is needed to be taken. And that's why I would expect, certainly it's difficult not to see why, that wasn't front and centre in terms of your overview, and that specific issue with respect to going concern wasn't dealt with in terms of your overview, in the stark terms it needed to be dealt with.
Senator, I acknowledge that it's not in the plain terms that I have used today. I can't change the
I know you
tenor
can't
of that,
change.
but I would suggest, Senator, that the report as a whole does provide the whole picture. And
Page 85, Professor Croucher, come on. Seriously, I mean, that should...
Scar, we are...
Well, my last question,
Yeah, last
seriously,
question.
don't you think... I mean, the other way you can approach this is have a summary page right up the front and detail the key issues. If you were to detail, say, the 5 key issues with respect to the Australian Human Rights Commission over that period of time for which this annual report relates, would the going concern issue be one of the 5 key issues?
yes, it would.
So why do we have to go to page 85 to see it?
Yeah, fair point, Senator, and I acknowledge the deficiencies in that regard.
Thank you.
Thanks very much, Senator Scar. We'll now move to Senator Grogan.
Yeah, I saw that.
In terms of reflecting on the annual report, it is probably worth noting that the ANEO put out their own report on this issue, which was publicly available. That the page numbering that Senator Scar has referred to is probably just a bit cute. Obviously, there was a financial issue. It was identified. You've worked alongside the Attorney-General and Finance to fix this. I do hope Senator Scar isn't implying any impropriety on the Attorney-General's actions within this matter.
No, he's not.
Jolly good.
Yeah, that's actually completely inappropriate, Senator Grogan.
Well, I
and
think
would
we're
ask
heading
you
down a
to
path.
withdraw
Well,
that, Chair.
Yeah, Senator Grogan,
If you had
the
listened to the
Minister
evidence,
has made a very
you would
good
understand that Ms Croucher has said she takes full responsibility
she has,
for the financial
and
mismanagement, and I would ask you to withdraw the comment you have just made.
my comment was referring to the production of these documentation.
No,
and
you made
so
a direct
I will
reflection.
withdraw. I will
Thank you.
withdraw
Thank
for the
you.
interpretation.
Thank you.
I will withdraw.
you.
Senator Grogan, do you have a question?
I do, Chair. Yes, I do have a question. Attorney General, can you? I assume that you have that you value the work of the Human Rights Commission. That would be an appropriate.
When you say value the work, what exactly do you mean?
You value the work that the Commission undertakes.
Absolutely.
In terms
It
of
takes
the
incredibly important
significant work that's
Correct.
been done by Kate Jenkins, the Sex Discrimination Commissioner, over the last significant number of months, dealing with issues of sexual discrimination and particularly dealing with the issues that we're facing within the Parliament.
That is correct. Senator, Commissioner Jenkins has done some excellent work, without a doubt. Without a doubt.
And the various other commissioners and the essential work that they undertake in terms of the rights of people within Australia and dealing with some of the challenges we face.
That is correct.
Excellent. The funding to the Human Rights Commission over a period of time is something I'd like to sort of look at. When Tony Abbott was Prime Minister, there was a slashing of the funding, and my understanding is that funding has not been restored since that time. That was some time ago.
What
and
I'll do is-
appreciating
Senator Grogan.
the equity injection that has been provided. Can you maybe take us through
The funding.
The funding?
Yep.
That would be really
Understood.
helpful.
So I think what you heard at the very beginning, and I'm happy to have the relevant official come to the table for you, is that when you look at the funding for 2022-23 versus the funding for 2013-14, the advice I have, it is a 22% increase on the 2013-2014 budget. The government obviously continues to provide stable funding to the Australian Human Rights Commission. The Commission's total operating funding for 2022-23 is $29.9 million. This comprises annual appropriation funding of $20.8 million and estimated revenue of $9.1 million from other government agencies. This is an increase from 2021-22, where the Commission's total operating funding for 2021-22 was $29.3 million, comprising annual appropriation funding of $20.7 million and estimated revenue of $8.6 million from other agencies. As we have discussed at previous estimates, the government has also provided a one-off equity injection of $16 million to assist the Commission to address the cash flow issues that it is currently experiencing and have been addressed by Professor Croucher to ensure that it returns to a sustainable footing. And as has also been gone through at other estimates, the Attorney General's Department is working closely with the Commission to identify ways in which the Commission is able to return to budget and get on that financial footing, given in particular the very serious financial mismanagement issues that Professor Croucher has said she takes responsibility for and have been identified. That is something that we are working through with the Commission. But I'm happy, that's my assessment. It might also be if Ms Chidgey can actually give you the broad overview of the funding.
Maybe we'll come to that in a minute, if that's okay. So the issue in terms of the staffing currently, the staffing required to discharge the responsibilities of the Commission, do you see a discrepancy between those two things?
I don't quite understand.
So do you
your
feel
question.
that the issue of how many staff is required to operate the functions of the Commission versus the available funding to pay for that said staff to function?
Well, I think given the financial mismanagement issues that have been raised, the government needs to work with the Commission through the process that has been put in place to ensure that it can return to budget. But certainly in working with the Commission, what we've done, and I think this was explored at previous estimates, we have provided the $16 million equity injection. And I think what was also discussed at previous estimates, given that it did not appear that the Commission had advised other commissioners of this, and I had discussed this with Ms Croucher, that the Commission is able to utilise this funding to retain existing staffing levels. This had been conveyed to Ms Croucher. I understand it has now been conveyed to the other commissioners to ensure that they understand that this funding is able to be utilised to maintain their existing staffing levels.
For what period of time?
Well, it's $16 million, so it is a considerable injection. And you would have heard both last estimates and again today, the process is now being worked through with the Commission in terms of what the funding may look like going forward.
But the $16 million is for as long as it's required, until it's spent, or does it have a profile?
I'll get Ms Chidgey to profile it for you.
Senator Sarah Chidgey, Deputy Secretary, Integrity International Group. So the $16 million is available to retain existing staffing levels, and I think it's already been mentioned that there's an arrangement for us to work through the Commission's funding arrangements and come back to government later this year to assess ongoing funding needs. It is the case that work is still being undertaken to cost the Commission's operations and determine what an appropriate funding level is for its functions. And so we in the Attorney General's Department and also officers in the Department of Finance are doing that work with the Commission to make sure there's an appropriate model and costings that can be provided. And in
so
the
it's
meantime,
an injection without necessarily a profile at this point while that work is ongoing?
That work is ongoing, and in the meantime that 16 million is available for the Commission to retain its existing staffing levels.
And I think also what you would have said, and I'm sure that you could possibly explore this in further detail, in terms of the statutory functions, etc., what are the statutory functions? Who actually determines whether or not the work is in accordance with the statutory functions? And I'm sure that there'll be an opportunity to explore that further. There are a number of issues that do need to be worked through. I mean, and as Professor Croucher has stated, it is just a very unfortunate position that the Commission finds itself in.
So,
One more minute, Senator Grogan.
Professor Croucher, can you just, how many staff do you currently have? Is it the 96 that was referenced previously?
The current level of staffing is around 101.7, but that includes... okay, just bear with me, Senator, thank you. Yes, 101.7 that are funded through our appropriation. We also have 13.8 staff who are funded through the Commonwealth Parliamentary Workplace Review to which the Attorney referred.
So project funded.
And there's also 36 staff on other projects that we're doing, like the collaboration with the Australian Defence Force, the Australian Federal Police, and it's just been announced we will have a continuing funding for a specific project with Australian Border Force as well. So it's unpacking what's external and what's internal. The numbers, the ASL numbers, combine it all. So part of the forensic work we've been doing is unpacking what are the numbers that we can afford within our core appropriation. So I mentioned 76 is the numbers within our core that we can afford. We currently have 101.7 full-time equivalents, and we are working to reduce that somewhat. And while it's entirely accurate to say that once the money is in our available to us, we can make decisions about it, but the parameters on which the money was given, as I understand them, was that 10 million of the 16 was to go towards the operating deficits, which is the area where we overspent, and I fully acknowledge that, and to support us to the end of this financial year, which still includes an operating loss, because we cannot afford 101, we can only afford 76. And 4 million.
So are you in the process then of reducing that staff number?
Yes, we are retaining core staff for commissioners, which is responds indeed to one of the points that the Attorney encouraged me in her letter. And structurally, it is what we recognise as core support for our commissioners. So the 10 is going towards the operating loss environment. 4 million is for employee liabilities and 2 million to fund redundancies. We are using some of the 4 million component towards supporting and as encouraged by the Attorney, to retain staff around the level of about 94 staff.
Senator Grogan, we will need to...
And just on that, Chair, just to confirm again, there did seem to be some confusion with the Commission as to how it could utilise the 16 million, which itself obviously raises some quite disturbing issues. But I have written to Ms Croucher, because clearly they needed it in in writing to understand what the instruction was. And I stated, I confirm the government's position is that the Commission may utilise the $16 million equity injection provided in the 2021-22 additional estimates to maintain current staffing levels, including to reallocate staff to support the Commissioners. I'm a little bit disturbed with the evidence that Professor Croucher has given that perhaps there's still not an understanding of this. So perhaps the Attorney-General's Department will clearly continue to work with the Commission, because I would have thought it was obvious what the letter says, but there does appear to be a continued misunderstanding, which we will ensure is yet again cleared up.
Thank you very much, Minister. Look, I just want to pick up on some of these concerns, and I'm frankly concerned about the human rights of your own staff, because we've now learned that you're planning to make these staff, or a number of staff, redundant because you haven't managed your budget with respect to staff salaries.
Chair, if I may, I don't agree with that proposition.
But you've just indicated that you will be making a number of staff redundant because you don't have the budget to pay for all staff salaries. Is that correct?
You coupled, if I may, we can check the Hansard, was a suggestion that it was because of mismanagement that we were making people redundant. Those propositions do not line up. We are needing to reduce our staffing because we have had this intense scrutiny on what we can afford. Clearly, we didn't pay that scrutiny before because we were spending too much on employees. Now we have...
So you've hired staff, you've hired too many staff for your budget, and now you are being placed in a position where you are going to have to make some staff redundant.
Indeed.
Due to the Commission's financial mismanagement. That's correct, isn't it, Professor?
Yes. In that sense, I agree with your proposition, Chair. What we are needing to do, though, now that we have a much greater understanding with the work that we've done together with the Department and the Department of Finance, is what we can afford. And that number is the stark reality that even if we retain the staff, reducing down to a level of 94, which we've been encouraged to try and maintain staff, unless we can secure positive outcomes to the conversations that indeed have been opened about what a functionally sustainable funding model looks like, we will run out of all of that cash again by June in 2024.
Well, I would put to you, President, and I'm absolutely stunned by the evidence that we're hearing this morning. This is shocking. And I would put to you that it's because of your gross financial mismanagement that some staff of the Commission are now facing the prospect of being made redundant. Can I just go to this issue? You said that you've been learning on the job and that you've learnt a lot as a result of these issues with the crisis of financial mismanagement, as I would put to you. What is your annual salary, Professor?
It's the Remuneration Tribunal allocation for me.
And what is that salary?
I can't tell you the specific number off the top of my head.
Well, could someone find out?
Yes, we certainly
Is it
can
in excess of $480,000 or around about that amount?
We can provide the specifics for you.
It's around about that amount though, isn't it? Close to $500,000 a year.
Yes, it is.
So I just would put to you, I'm very surprised that someone of your seniority does not have these skills to oversee the Commission's operations under circumstances where, you have now got yourself into a crisis of financial mismanagement.
Yes, I recognise I acknowledge my responsibility ultimately, and I have sought to enhance my own abilities to understand all of the financial particulars through my own work with the Institute of Company Directors. However, and this is not
talking of the Institute
Chair.
of Company Directors, if you were a company in the private sector operating essentially insolvent, that would be a breach of directors' duties.
Indeed, but we are not a company in that context. Chair, if I may say...
No, I understand that, but these are very serious matters.
Indeed, I have
because you're effectively running the Commission in a manner which would otherwise in the private sector be insolvent, which is a very serious breach of the law.
Indeed. And so, Chair, when it comes to how much of the equity injection that we spend supporting a staffing level that we have recognised is not affordable, we have to apply a good measure of prudence in terms of how quickly we run that down, because we will be in the same position that we were in that generated this crisis. Chair, if I may say...
Look, I'm just conscious of time, Professor. I do want to just go to some of your statutory functions, and I know that the Commission receives a lot of funding from departments on a project basis. Have concerns been raised regarding the Commission's record keeping, cost apportionment and barriers between project and non-project staff, which and whether they would meet the standards outlined by the Department of Finance for external charging activities undertaken by government?
No, not to my knowledge. All of the external projects are undertaken with proper contracts in place, scrutinised fully by our legal section. I can give you all of the details of those external projects if you require that.
But I'm asking whether concerns have been raised about the projects that the Commission is undertaking, including whether they are within your statutory obligations.
No questions have been raised about.
Do you have concerns?
No. But the external projects that we undertake, we scrutinise very closely. If we had questions, then we would not take on projects that we consider would run counter or contrary to our standing as an independent body.
And are you taking on projects that are strictly within the definition of your statutory obligations?
I would say all of our projects sit within our range of functions. We have a very wide mandate, Chair.
Yeah, we would appreciate some further information on that issue on notice. So if you can demonstrate that every project that you are taking on is within your statutory obligations, because I certainly do have concerns. Is there been any cost shifting between different departments? I mean, your complaints division is a very important role of the Commission. Have you been moving funds between different divisions to pay for shortfalls in other areas? Have you been, for instance, dipping into the complaints division or the money allocated for complaints management?
It doesn't quite work in that way, Chair. It is certainly true that in order to support our ongoing operations, we have had to fund from within money that is in our unearned revenue account, with strict controls, but now with the equity injection we have replenished that account. The approach that we have taken is entirely lawful and is now completely vigilantly controlled.
So just to be clear, that is a yes, that you have been cost shifting internally?
Not cost shifting. I dispute that analysis.
Or taking money from one part of the Commission's operations to fund other operations, but so there's been no movement of funding between internal divisions of the Commission?
No, not in the sense that you ask. I've also
is there in any other sense?
Only in the sense that when we have been running out of our appropriated amount, we have had to call upon the money that was set aside, that came into us as project money. It is available to use. We don't like to do that.
So you're taking money allocated for projects and moving that into your internal functions, is that correct?
Not moving it in that way, Chair.
Expending it.
But rather using it.
Utilising it.
Paying for staff salaries.
Right.
Which is something that we shouldn't have to do.
So in fact you are cost shifting?
I wouldn't describe it in that way.
You are moving money around, allocated for projects, to plug a big gap in your internal staff salary budget.
With the agreement of the Attorney-General's Department in the use, because until the $16 million came in, we were in a position where we needed to draw upon our unearned revenue account with full awareness and understanding, because it is anticipated that the 16 million, which was the equity injection, until that came in, we wouldn't have been able to pay staff salaries.
I mean, that 16 million really has been provided to effectively manage the Commission's incompetence, I would put to you.
The 16 million has been provided, 10 million to deal with the operating loss factor, with the conversation about what controls we need to going forward to ensure that we are not in that position again. But in order
this is
not to be,
this is a bailout because of
That
the
is a fair
Commission's
description.
financial incompetence, isn't it, President?
it is a fair description to say that it is a bailout to deal with operating losses that we should not have incurred by virtue of overspending in relation to staff hiring.
Do you apologise for what's occurred?
Absolutely. I apologised to the Commission in the Commission papers of the December Commission papers. I recorded in our papers, which are a public record, that for any failings that are attributable to me, as the accountable authority, I fully apologise. I am sorry for what occurred. To say that I operate in a framework of delegation like other agency heads who happen to be accountable authorities is no answer to the responsibility that I carry, for which I apologised to my Commissioner colleagues, to the staff, publicly on record in the Commission papers, and in response to your question, yes, Chair.
So other people in your position might consider not continuing in the position by reason of this very serious failure that has now emerged. What's your position in relation to your own position?
My
going
position
forward?
is that I want to ensure that it doesn't happen again and that all the controls are absolutely in place to support the Commissioners in their work, to support the Commission.
So you won't be stepping down at all?
No.
Okay. Thank you very much, President. I'll now
May
move
I
to
also
other...
give you... Sorry, Chair, you did ask about my salary. It's been confirmed it's 461,603, so it's less than 480.
And plus superannuation? Does that include superannuation?
I'll have to seek
Thank you.
advice on that.
Salary.
Base salary.
That's base salary. So if you could provide us with the full information in relation to your total remuneration package, that would be appreciated.
Absolutely.
Thank you very much. I think it's around, including superannuation. I'm just getting some advice.
I think it's 488.
488,000,
Around
including superannuation.
Yeah, your description of it before was entirely accurate.
Thank you very much, President. I'll now move to other senators. Senator Grogan, do you have any more questions? That being the case, if there are no more questions, we will thank you very much, President, for your
not for my colleagues.
time.
The other commissioners are all here in attendance as well.
No, we don't have any other questions. We thank you very much for your time today and for your attendance and for your evidence. Thank you so much.
Thank you, Chair.
I think, Chair, Assistant Minister Stoker may now be joining for the court.
We might just suspend
and then work out.
We will suspend the committee for 5 minutes and until we establish the program going forward. The committee is suspended. We will resume in 5 minutes. The committee is now in session. Just to update everyone on the schedule, we are now going to the Federal Circuit and Family Court of Australia. I do call officers from the Federal Circuit and Family Court. We will endeavour to then move directly to the other agencies, the Office of the Australian Information Commissioner, and then the Royal Commissions into Violence, Abuse, Neglect and Exploitation of People with Disability, as well as Defence and Veteran Suicide. We are endeavouring to move through all of those agencies before lunch, and then in fact we will be adjourning, and hopefully we will finish based on Senator Carr's advice, and I have great deference to Senator Carr on his last day, in the next 45 minutes or so. Welcome to the Federal Circuit and Family Court of Australia. Would you like to make an opening statement before we go to questions?
Thank you, Chair. David Pringle, CEO and Principal Registrar of the Federal Circuit and Family Court of Australia.
Hello, Mr Pringle. Welcome again.
Thank you. It was only recently we were here in February. I appear again with Virginia Wilson, Anne-Marie Rice, Janet Carmichael and Lisa O'Neill. We do not have any opening statement, given how recently we appeared, and my opening statement, I'd be happy to refer back to that if needed at any point, from 15 February.
Thanks, Mr Pringle. We'll now go to questions from senators, and Senator Carr.
Thank you, Mr Pringle. And if you could assist me, I would appreciate. The attorney made some statements yesterday regarding the issues that had been canvassed in a statement that the Federal Circuit and Family Court published on its website on the Thursday, the 31st of March. Now, I understand the statement was issued because, in the court's view, there has come to light some serious matters in relation to jurisdiction of what is now called Division 1 of the court. And can you explain precisely what the issue has been?
Yes, Senator. The issue, and I've got to stress it's only a potential issue, is in relation to a finite number of cases that were in existence in Division 1, or the former Family Court of Australia, and whether or not the transitional provisions as they're currently worded had the effect of stripping jurisdiction from Division 1 in respect of those finite number of cases. Again, it is a potential issue only, and for the avoidance of doubt, to avoid confusion, and as an abundance of caution, the court issued a statement to clarify a number of matters. I'd be happy to clarify those matters.
Well, you'll have an opportunity to do that. I just want to be clear, though. Is it correct for me to be able to argue that any order that had been made by Division 1 judges in the family law proceedings that originated in the family court prior to the merger on the 1st of September may have been regarded as legally invalid as a result of the drafting of the legislation that had been passed by the Parliament?
I don't think that's how I would characterise it, Senator, and the reason is that it's pretty well established principle of law that a superior court, and the Family Court or Division 1 is one of those, any orders made by a superior court are valid and binding unless they're set aside by an appellate court.
Yes, but that requires someone to take deliberative action, doesn't it?
It would, yes.
Right. So the issue then arises, the potential arises whereby someone makes an appeal on any orders. Is that the nub of the problem?
If somebody was to bring an appellate process, and if that was to be successful, that would be the only circumstance in which the issue of jurisdiction would then arise.
Okay. Now, given that family law matters are notoriously difficult, is it not a real threat that someone might seek to challenge the orders by an appeal?
It's possible that somebody could bring an appellate process, but when you factor in that across both our divisions we do 120,000 filings a year, and we're talking here about a relatively small number of cases that were in existence in Division 1 prior to 1 September, this, I've got to stress, does not apply to any filing that has happened since 1 September, and it does not apply to any new filing now. It is really very much a quarantine issue.
I understand that. I understand the point you make. Now, Mr Pringle, you say a small number of cases. I've seen a figure of 200. Would that be anywhere near the number of cases involved?
In regard to those matters that are being finalised, that could be, you see, the vast majority of cases finalise in the court, not through a judicial determination, but through the consent of the parties. So it's pretty unlikely, one would think, that through a consent resolution between the parties that either party would want to re-enliven the issue. So I think when you look at the percentage of judicial decisions that actually determine the matter, it's a relatively small number. So whether it's a couple of hundred or thereabouts in terms of those matters that have already been finalised, that would be perhaps a reasonable estimate, but it's very hard to say with certainty.
Sure, thank you. 200 is reasonable, though. Look, just that the way it was put to us yesterday, that the proposition now is that the recent judgments of the court confirm the transfers from Division 1 back to Division 2 and back again resolve the jurisdictional problem, you know, the sort of 1-to-1 process of transfer. Now, that does not, the question I put to you, I can understand that, and that much that's quite, I understand what the attorney was saying, but what I'm concerned to is, can you tell me whether or not that method of resolving this won't do anything to provide jurisdiction orders for those that are already been made?
Well, that's right, Senator, but we've got to start from the proposition that, number one, the orders on their face are binding. Number two, it's only if there is a jurisdictional issue and only if those orders are set aside that there's a problem. And number three, the court has taken the preemptive step and the prudent cautious step, just for the avoidance of doubt, to do the transfer mechanism back up again to ensure that there is jurisdiction.
I think I could follow your line of argument. But so just give me an example. If a parenting order was made in a matter which is commenced in Division 1 prior to the merger,
yes,
and although the orders of a Superior Court are valid and lawful until they're set aside,
yes,
if a parenting order is breached, is it true that it'd be difficult to obtain an enforcement order of recovery order when the original order was made without jurisdiction?
Well, I think that's a circular argument, Senator, with respect. Well, you're presupposing there that there is a jurisdictional problem. On the premise of what you just laid out to me, there isn't a jurisdictional problem because there has been valid orders made and there is no appellate decisions setting aside those orders. So there should be no difficulty on the face of it with enforcement of any existing orders. And over and above that, the court has taken the step with all those cases that are currently on foot of transferring them down and back up again to ensure, for the avoidance of doubt, that jurisdiction exists.
See, the way it's put to me is that, given that circumstance, the court, and being aware of the issue, it would be correct that a judge would be bound to, at the very least, raise this with the parties, one or both of whom may well be unrepresented, before an order could be contemplated. Is that right?
Well, whether a judge feels it's necessary to do that or not is a matter for judges. As you know, they're independent decision makers. But the best indication I can give you about where this is headed is that we've had two decisions that touch on this topic, both of which have said that the transfer mechanisms are valid, and one of which has already said that the jurisdictional issue was not an issue. So it is still early days, but the indicators are that the judges who are looking at this issue are seeing both the jurisdictional issue and the transfer mechanism as not an issue.
Look,
Senator Carr, it might be helpful to add at this point that while the matter was raised by Justice Hogan, somebody who I think is well and truly on the record as being somebody who was not enthusiastic about the merger occurring. Nevertheless, despite that stated case, there has since been a decision of a Division 1 judge confirming that the court has the power to hear legacy cases in Division 1 and that the power to transfer is valid. Nevertheless, of course, we've had Mr Pringle put on record the steps that are being taken to put beyond any doubt whatsoever the validity of these things, so that in the time between when the full court of 5 deals with that, and we expect that to be done by the 12th of May, there is absolutely no uncertainty, and to flip that over, there is absolute certainty that those who are coming before the court are going to get the clarity and the certainty that they are seeking.
sure. That goes to questions that are dealt with now. The issue is to deal with matters that originated in the family court prior to the merger on the 1st of September. There's a group of 200 that this matter affects. That is the situation, isn't it?
I understand what you say, but quite frankly, that concern is at worst manufactured, at best speculative, and not something that we anticipate on any of the advice that is available to us to be something that represents a real risk.
Okay. So, Mr Pringle, your notice on the court's website it's under the tab for lawyers. I asked a similar question to the department yesterday, and it's for lawyers, quote, updates to the profession. Has there been any attempt to notify unrepresented litigants in these matters that might be affected by this potential difficulty?
Senator, the notice has been circulated much more broadly than the profession itself. It's available on our website and it's sent out through our media section. It's important to emphasise that the process of transfers that has been being undertaken to avoid doubt on this jurisdictional issue is an administrative process. The imperative of the court is to try and make sure that there's no confusion out there, but secondly, that this process doesn't lead to any delay or cost for the parties. Sure. So the last thing we would want to do is to cause anxiety or confusion for unrepresented litigants who we might feel that they would have to go and get a lawyer and come into court and deal with the issue. We're dealing with this on an administrative basis because that's the most effective and efficient way to deal with that potential matter that may arise. And the circulation of the notice has gone beyond the profession to the normal media outlet that we do for those sorts of notifications.
So Mr Pringle, given what you've said to us, and acknowledging that the Division 1 of the Family Court, that's the Superior Family Court, deals with the most difficult of cases, family breakdowns, including cases where children and often women are at risk in terms of their mental and physical health. There are potentially 200 incidents here. Just ask you that given that some of these orders were made to determine critical matters such as where children live, when they see each parent, that the invalidation of those orders could in fact put children at risk. What do you say to that?
Senator, it's impossible for me to comment on that. Those orders are valid as they currently stand.
Until they're challenged. That's the point.
No, until they're successfully set aside by an appellate court.
But I'm saying to you, they're valid so long as no one raises an appeal. That's the point.
No, they're valid until an
the
appeal
court
against them
finds.
succeeds.
All right, okay.
So it's a different thing.
Yeah, they've actually got to be. That's got to go through due process as well. But
No,
my
but
point
isn't
is
this highly
they're not
speculative?
secure.
Yes.
This is the point. They're not secure. You're assuming they won't be challenged. That's the nub of the proposition that's being put to us.
Senator Carr, I will echo my words once more. This is a challenge that has been at worst manufactured, at best is speculative, and we have enormous confidence that there is no difficulty that will be supported by those who bear responsibility for determining these matters.
Okay, but
If we operated on that basis for every appeal that was lodged in every court, when so few of them in fact succeed, our justice system would be operating on a very different footing.
But look, the problem you've got here is that the court itself felt it necessary to post this notice.
Well, Justice Hogan thought it was necessary to do so, and
So
Justice
it's not
Hogan's,
valid. It's not valid for the court's action?
Justice Hogan's colleague of the same court has resolved that issue in the time subsequent. So the best information and the most recent decision we have from that court says that this matter raised by Justice Hogan is not in fact an issue.
So if I could ask, Mr Pringle, in the statement the court actually issued, it said that you thought there was in fact a legislative mistake. The court statement included...
That's not quite right, Senator.
Sorry?
That's not quite right, Senator. There's an issue that's been a potential issue that's been raised. We've acknowledged there's a potential issue that's been raised, but the primary purpose of the statement was to make sure that there wasn't any confusion that new proceedings
Mr Pringle,
1 September.
I understand that. Look, Mr Pringle,
Senator
we're
we
short
will
of
need to
time,
wrap up too.
and so I just want to get you... You said in your statement, quote, the court will work with government to ensure a legislative clarification can be progressed at the earliest opportunity. what was meant by the term legislative clarification.
If there's to be a legislative clarification, that's a matter for government. Obviously, the courts would work with government to make sure that legislation would be effective.
Senator Carr, we are well over time.
Look, I've nearly finished this whole section,
All
so
right,
if you could just...
can just
I
give
think
you
we
some
can
grace because
see,
it's your last
see,
day.
you said, but the court said, not the government, the court said, the court will work with government to ensure a legislative clarification. It can be progressed at the earliest opportunity. Who asked for those words, legislative clarification, to be included in the statement?
I can't say who asked for those words to be included, but the process, Senator, is that it's very usual. This isn't the first time that there's been some question raised about certain legislative provisions. It's very usual for a court to work closely with government to ensure that if there is to be any addressing of that matter, that it's done with the court's contributions.
Okay, I think it's, correct me, I think it's unusual for a statement like this to appear.
Respectfully, Senator Carr, it is utterly normal for the courts and government to work together to put any concern that might exist in any corner of our community to rest as carefully and as completely as possible.
So,
I think, Senator Carr, you would be wise to read that as being the court will work with government to ensure a legislative clarification can be progressed at the earliest opportunity whenever such a requirement is demonstrated, but that does not mean it has been demonstrated in the present case.
Look, it's a simple,
Senator Carr, we are well over time.
I know,
in
just a
excess
very
of 15
simple
minutes.
question. What is the legislative clarification that is required?
There is no admission that it is required. It is that government and the court work together at all times to make sure any concern is put to rest as soon as possible.
Thanks very much, Senator Carr. So just wanting to alleviate any concerns for parties who have been or are in the family court, while there's been a concern raised about jurisdiction, given the subsequent decision made that there is no issue in relation to the legislation governing the merging of the two courts, the current position is, Minister, just to be clear, that every order made by the previous two courts before they merged is sound, and there's no suggestion that any such order, whether it be a parental order or a property order, there's no suggestion that any of those orders is not otherwise enforceable.
There has been no ruling of any court to suggest that there is any doubt whatsoever. So parties and holders of orders can have confidence that they are dealing with a jurisdiction that is valid, with orders that have been validly made. And it is also, I think, important to point out that any concern that Justice Hogan might have raised was more than put to bed by her colleague, Justice Aldridge, some days later. There is no need for concern, and there is every reason for Australians to continue to use this court with confidence, including those who use the transitional period.
So the statement issued by the Federal Circuit and Family Court of Australia dated 31st of March precedes the judgment of Justice Aldridge, which confirms there is no issue in relation to the enforceability of orders.
That's correct, Chair.
Under the previous two-court regime.
That's correct, Chair.
So, Mr Pringle, on that basis, will the court be revising its advice given the decision of Justice Aldridge, or will the court be reviewing its statement of the 31st of March?
Look, if Mr
Chair,
Pringle, if I might jump in there, I beg your pardon, I don't wish you any discourtesy. Look, I would expect the court, and of course Mr Pringle will speak for himself, to leave the matter where it stands until the matter has been heard by the bench of five. But let the record show there is every reason for Australians to feel very comfortable with the jurisdiction of the court.
All right, look, I might leave it there. Thanks very much, Minister. Look, I just want to briefly move, Mr Pringle, to some of the very positive budget announcements made for the Federal Circuit and Family Court, including more money for the Lighthouse Project, funding for the Launceston and Rockhampton registries. Could you just briefly run through those measures and what difference this will make to the functioning of the court?
Yes, Chair, thank you. This budget delivered some very significant additional funding for the courts, for which we're of course very grateful. The funding was in the order of $64 million, $63.7 million received directly by the courts. That's of course in addition to important systemic funding for legal aid, which the court is very supportive of, in the order of $24 million. Of the $63.7 million, $59.9 million of that was committed to what we consider to be a really important development within the courts to address family violence and other major risk factors, and that is extension of the Lighthouse Project model from the 3 existing pilot sites where it's been very successful so far to all 15 family law registries nationally, and to further extend that model to not just parenting only proceedings, but to parenting and proceedings that have a property aspect to those parenting matters as well. So it extends the number of proceedings and the number of locations very significantly, and that includes to a number of regional locations. The other key component of that $63.7 million is $8.8 million, which was committed over the forward estimates to the engagement of a number of Indigenous liaison officers who will work within the court to support court lists, some of which are specific Indigenous lists, and will support the rest of the case management pathway, including potentially interviews of Aboriginal or Torres Strait Islander families, and also, of course, any dispute resolution processes undertaken with those families. It's very exciting to have the ability to engage those Indigenous liaison officers, because we know that many of the risk factors that are being highlighted by the Lighthouse Project play out very significantly within those communities, and the more assistance we can provide, the better. The model itself is pioneering, it's world leading. It has 2 primary aims. The first is to provide direct support to those people who are screening high risk, to make sure that they get referred urgently to the necessary health and other services available. And that includes, of course, children who may be at risk. And the second is to inform our case management pathway so that we understand what is the best case management model that can be applied, whether the matter screens high risk, moderate or lower risk. So it is really critical to us being able to properly address these major risk factors within the court. That builds on top of the very significant funding we got last financial year of in the order of $100 million, most of which was ongoing funding for the very significant reforms, including the harmonisation of the courts and making sure that registrars played a critical role in relieving some of the pressures on judges. So it's very exciting to see that that will come online soon.
Now, you have been operating as a combined court since September of last year. How are things progressing, and do you think that parties before the court are seeing a substantial improvement in terms of their experience of being in the family court, which of course isn't always positive for many people who need to go to the family court, but are you seeing on the ground marked improvements?
Indeed we are, Chair. I think I reported back in February in my statement some of the early indicators that were very positive in nature. I'd be happy to give you an update on those as they currently stand. But all of the indicators are going in the right direction at this stage. registrars. The model, as you know, in terms of our reforms was for registrars, including senior judicial registrars, to take as much of the case management load as possible off judges so that they would be freed up to be able to deal with their trials and judgments as early as they possibly can. That is happening. Back in February, when I reported, registrars had undertaken no less than 13,000 court hearings since 1 September, which judges would otherwise have had to deal with. That's now in excess of 18,000 court hearings since 1 September. The docket sizes that Division 2 judges had to deal with, which was, as we know, in the mid-300s not so long ago, dropped to February to 193 on average, and that has now dropped to 167 on average for Division 2 judges. There has been, of course, more appointments as well, judicial appointments, which 29 were made in the year of 2021. But since then, and since last estimates, there's been a further 9 appointments, and those additional resources will be critical in ensuring that we can deal with matters quickly. Dispute resolution, which is a very major focus of the courts, has increased. I think I said over the last 16 to 18 months, there is about 7,500 such events. There's now nearly 8,500 such events that has taken place. And the backlog or pending caseload, which was very significant and continues to be in the courts, and we're addressing as quickly as we possibly can. I'd mentioned last February that had been reduced by some 12% since 1 September. That's now been reduced by approximately 14%. So all of those indicators are going in the right direction. It is still relatively early, but those indicators are very positive.
Thank you very much, Mr Pringle. I will now hand over to Senator Grogan.
Thank you. Is it correct that the courts are seeking to implement a new operational model, obviously given the merge and the changes, that makes sense, and that there are staff changes that are associated with that?
Senator, there is a process afoot at the moment to rearrange, is probably the best way of putting it, some of the current registry arrangements within the courts. However, that's at a fairly early stage of its process. It's currently in the early stages of consultation with staff and other cohorts. And I need to stress that the shared services, registry services arrangements within the courts, so that spans not just our courts but the Federal Court and others, is an area that is managed by the Federal Court of Australia entity. They have responsibility and accountability for those services. So there's a limit to how much I can go into that today. It's not my area of responsibility, but you're right, there is a process taking place at the moment.
So would you be aware of the general frame of this adjustment? My understanding is that there is an impact on the APS 3, APS 2 and the APS 4 positions, with the APS 4 positions requiring some form of legal background or qualification?
Senator, it's really a matter that I would ask you to direct on notice to the Federal Court entity. The reality is that it's an early process, it's a proposed process. What exactly that ends up looking like and how that feedback from the staff and others is going is a matter that only they would be able to clarify for you.
Okay, because we tried asking these questions yesterday and got bounced to you.
Well, the relevant court would be the Federal Court, which from a Federal Court entity point of view, that not being called as I understand at this time, so my recommendation would be a question on notice there would be the more effective way of dealing with it. We don't have responsibility, the Federal Circuit and Family Court of Australia, for those shared services and how they're implemented.
Thank you.
Thank you very much, Senator Grogan. Any other questions from senators? Look, there being no other questions, Mr Pringle, and to other members of the court, thank you so much for your attendance today and for your commitment and for all the work that you do. We do very much appreciate it.
Thank you, Chair. Thank you, Senators.
I now call officers from the Office of the Australian Information Commissioner. Ms Falk, good afternoon.
Good afternoon, Chair.
As you just settle yourself at the table, thank you so much for being here and accommodating a variation in our schedule today. Do you have an opening statement before we go to questions?
I do not, Chair. Thank you.
I'm seeking the call from Senator Grogan.
Thank you. Good afternoon. Ms Falk, at Senate estimates in October last year, and again in February this year, you were asked about an FOI application by the 9 newspapers in relating to a letter from the AFP to Peter Dutton in relation to that police probe into George Christensen's frequent travel to the Philippines. Mr Christensen has objected to the release of that letter. Is that still the situation?
So, Chair, that matter is still under active consideration. I advised the committee on a question on notice that I anticipate it will be resolved by the end of this financial year. And in relation to third parties and any submissions they may or may not have made, they are confidential at this stage.
Mm-hmm. Are you still expecting that to be done by the end of the financial year?
Yes, I am, Chair. Senator, excuse me.
And we are almost there at the end of the financial year, almost. Do you think it'll be completed in time prior to the election, or will we be waiting till the end of the financial year, do you think?
I'm not able to give you that level of detail today, Senator.
Okay. It would be rotten timing if an issue like this was to languish on the eve of a federal election. Do you see any sort of compunction to try and finish that review before the election is called?
Senator, we've been progressing all matters that are within the office's remit as quickly as we can, and we continue to do so. We have completed more matters this year to date than we did for the end of the financial year last year. So we continue to progress matters and to expedite as far as we possibly can.
Okay. So we'll just wait and see. Hopefully we will get to see the results of that review. That's it from me, Chair. Thank you.
Thank you very much, Senator Grogan. Ms Falk, just wanted an update on your litigation with Facebook. Could you provide an update to the committee?
Oh yes, thank you, Chair. So the committee will be aware that I have taken civil penalty proceedings regarding Facebook Inc and Facebook Ireland, alleging that they have engaged in serious and or repeated interferences with Australians' personal information. I lodged those proceedings a little over 2 years ago in the Federal Court, and Facebook Inc contested the jurisdiction of the Privacy Act in relation to them. That matter was heard by the court and found that there was a prima facie case for Facebook Inc to answer. Facebook Inc appealed that to the full bench of the Federal Court, who also found that there was a prima facie case to answer, and Facebook Inc has now appealed that finding to the High Court, seeking leave to appeal.
And when will that decision be known as to whether leave will be granted?
I'd have to take that on notice to ensure that I give the correct court proceeding date, Chair.
Is there anything that you can say in relation to the conduct of Facebook in these proceedings? It's obviously very disappointing that they are, can I just say this colloquially, seeking to avoid the jurisdiction of the court?
Chair, my view is that Facebook Inc is subject to the jurisdiction of the court. My view is that global companies who are carrying on a business in Australia and collecting or holding the personal information of Australians need to comply with our domestic law. Of course, every litigant is entitled to defend their case, but I think that all Australians and the community expects that global corporations who are monetising their personal information will comply with their domestic laws.
I mean, this is obviously very serious allegations that you're making against Facebook. Can you just explain those in a bit more detail, the seriousness of this particular case?
So we allege that Facebook that it unlawfully disclosed the information of Australians to an application, This Is Your Digital Life, and that it used default settings that prioritise the disclosure of information beyond the expectations of users at the expense of privacy. And that put Australians' personal information at risk of being disclosed to Cambridge Analytica and being used for political profiling purposes.
All right, well, look, thank you very much. All the very best of luck with that litigation. It's very important that these large tech giants are held to account, and I wish you all the very best, Ms Falk. Any other questions for the Commissioner? No. There being no other questions, it was a brief appearance today, but we do very much appreciate your time and your evidence today. Thank you so much indeed.
Thank you, Chair.
I'm now going to call officers from the Royal Commission into Violence, Abuse, Neglect and Exploitation of People with Disability.
Good to see you, Angeline.
Mr Cronin and Ms Crawshaw, welcome. Thank you very much for attending today. Do you have an opening statement?
Paul Cronin, Official Secretary, Disability Royal Commission. No, I don't, Chair.
Thanks, Mr Cronin. We'll go to questions. And Senator Carr is seeking the call.
I think we've got our problems here. Bear with me for a minute.
That's right.
Have you got the particular matter? Have you got, you do it. You do it.
Good afternoon. Thank you. Sorry about that.
That's all right. Senator Grogan.
Could you tell us how many submissions the Royal Commission received in relation to sexual and domestic violence, family violence, prior to making a decision to hold the hearing into these specific issues?
Thank you, Senator. I'm not sure that we have that granular detail on submissions. We have total numbers, but I'll just ask Ms Crawshaw if we have that level of detail.
Yeah, no, you're correct. It's certainly something we can take on notice for you, though.
Cool. Because I'm assuming that from the hearings you've had so far, it's come up as a significant line of inquiry for you.
Correct, Senator. We receive a range of submissions as well as commissioners sit at private sessions, as well as we have a range of community engagement activities. I think it's fair to say that particular issue has been one of the central themes that has appeared through all of those engagement formats for us.
Do you have any data regarding the submissions you received in related to various subsets of your commission inquiry?
I don't think we have those immediately at hand.
Because otherwise I'm just going to ask you a series of questions and you're going to say you haven't got it. So I just asked that up front. Maybe you could take on notice to give us a breakdown of the submissions that you've received and where they sit in terms of the lines of inquiry within your reference.
We're certainly able to break them down by theme and area.
That would be great.
And we'll take that on notice and we'll prepare a response that addresses that for you.
Thank you very much. Now, and I suppose you may not be able to answer this one either, but I'm interested to know, there was a media release that came out on the 28th of March, which was the Survivors to Give Evidence media release that you put out. And we're just wondering if that kind of publicity was creating a greater tick up in the number of people submitting to the inquiry. You may have a sense of that just on the vibe, as it were, as opposed to on the numbers.
I think we can answer you on the numbers as well, Senator. Okay. We launched a national advertising campaign on the 22nd of February this year. And what we've seen as a result of that campaign, which involved print media, radio, social media, and similar types of, and other social media types, is a significant uptick in submissions to the Royal Commission, as well as registrations for private sessions. As part of that national advertising campaign, the messages we were looking to get out there to the community was, in addition to that we're here, but also that our private session registrations will close mid-year, our submissions will close at the end of this year. Any submissions made to us in confidence will be kept in confidence. So please come forward with your stories and tell us. And that's seen a significant increase in numbers for us. Ms Crawshaw can give you the actual sort of the more recent month-on-month increases as a result of that campaign.
Yeah, since the start of the advertising campaign, we've seen a 250% increase in private sessions registration, so it's quite sizable, and a 200% increase in the number of submissions that we've received in that time.
Wow, that is significant.
It is.
So with people making submissions, could you just take us through the level of support that you may provide or may be provided by others in terms of, this is obviously an enormous personal pressure and challenge for many people to be so brave as to come forward and tell their stories when they can be so deeply personal and intensely challenging and traumatic. Can you just talk us through what kind of supports you've set up from a structural perspective to help those people through that process?
Yes, certainly, Senator. I might ask Ms Crawshaw to walk you through that. That's
yes,
okay.
Absolutely. So I can talk you through the process for people that are making submissions, as well as people that are registering for private sessions. With a submission, it does, I guess, depend on the person, whether or not they have had previous engagement with us, because often people will just make a submission via our website, and in that instance we will respond to them via email, recognise, let them know that we have received their submission, and in that email list a number of different supports. Then once we've had time to actually reflect and code and process and analyse the submission, we send further follow-up email that just says, that outlines what we've received from them, how the Commission will use that information, and again provides those supports. And that's generally by the way of the funded support services that are funded through the Department of Social Services. With private sessions, that's obviously a little bit different because we're engaging with people in a more personal way. Once they register with them, someone from our engagement team will get in touch with them and talk through any accessibility requirements that they might have, whether or not they might need to speak to one of our in-house counsellors at that time, and also make appropriate referrals to either legal services or a funded support service as well. We have an in-house counselling and support team that are also available for people on the lead up to the private session if they might need it, on the day of their private session, and then following their private session. And all our counsellors have experience working with people with disability and a lot of experience working in a trauma-informed framework as well.
Great, thank you. Have you received any complaints relating to the reduction in support to NDIS participants, so plan cuts, effectively?
Senator, I might just ask Ms Crawshaw if we have those details. Rather than speculate, I'll pass to Ms Crawshaw.
We certainly have heard experiences in that vein in our private sessions and in our submissions. I don't have the numbers for you, and I don't know if I would actually be able to break that down with respect to private sessions, because we've held over 900 private sessions and we've had over 4,000 submissions, and that level of granular detail can be a little bit tricky, but what we can do is we can take that away and see what we might be able to find out for you.
Cool. Well, if I can just run you through what would be great to get from you, basically how many submissions you've received in total, broken down by the issue. So obviously this issue of sexual and domestic and family violence, it would be good to understand what the numbers are there. And also, I think the total number of submissions, themes that you're seeing come through, the number of submissions from those, and I think, and of course, specifically, a number of issues that have been raised regarding the NDIS and particularly any reduction in plans. That would be really good, particularly if you can, and it depends on whether your data can support this at this point in time, break that down by disability, type and nature of the complaint about the service, about the NDIS.
What I can do, Senator, is give you the main themes that we have received. So they're quite high level, but I have them listed here. And that is around homes and living, health, autonomy, community attitudes and participation, the NDIS, education and the impact of the COVID-19 pandemic. With respect to total submissions received, we have received 4,156 as of yesterday.
Great. Thank you. Thank you very much.
Thank you very much, Senator Grogan. Look, there are no more questions from senators, so this is quite a brief appearance. We do very much thank you for your time and for your evidence today, and we want to wish the Royal Commission all the very best as you continue your very important work.
Thank you, Chair.
Thank you so much.
Senators.
Thank you.
I now call officers from the Royal Commission into Defence and Veteran Suicide.
This is the last.
This is the last one, yeah.
Welcome.
Mr Popple, good afternoon and a very warm welcome to you.
Good afternoon.
Could I ask if you would like to make an opening statement?
No, thanks, Senator.
Thanks very much, Mr Popple. We will go to questions.
Thank you very much.
Senator Carr.
Thank you, Mr Popple. Now, you've received, 1,300 submissions. Do you intend to publish all the submissions where the submitter has actually agreed to make their name public?
Senator, we may not publish all of those submissions. We intend to publish some of them, and we also intend, where appropriate, to redact those submissions before publication because, as you'd understand, frequently they include personal information, not necessarily just of the person who's made the submission.
But that'd be with the agreement of the submitter, would it?
When people make submissions, they are asked a number of questions. One of those is whether they would agree to their submission being published. We certainly would not publish a submission if the submitter has not agreed to
So which ones will you not publish that the submitter has asked to be published? Is there any you'd suppress?
Oh, we're certainly not suppressing anything, Senator. It just might be that there is material in there that can't be published because of its nature. I mean, as I said, if it contains personal information relating to other people, and not much more, then it may not be appropriate to publish that.
So you've reserved the right to withhold matters that might be defamatory, for instance? Is that the sort of
Certainly,
thing?
yes.
Is that the sort of restriction? I mean, we have similar rules in the Senate. There's matters that aren't published if people don't have the right to reply, but ours are covered by parliamentary privilege. Yours are not, are they?
That's right. And, Senator, I wouldn't express it quite like that. I wouldn't say we're reserving the right to withhold. We'd be choosing which of the submissions to publish.
Sorry, so how many do you feel that you will withhold?
Well, I'm not going to withhold any, Senator, but we'll publish some, if not all, of the submissions that have been made where the submitter is indicated they'd like to be published.
Okay, I just want to be clear because, I mean, people are anxious about making sure their views are heard. Now, there are legitimate restrictions on free speech. Clearly, defamation is one. But apart from those types of restrictions, your intention is to publish?
Yes, and Senator, when you say their views have been heard, of course, all of the submissions are read and processed, and some of them go on to...
That might be true.
Yeah.
That might,
so they are heard in that sense by the Royal Commission.
But the point of the Commission is also to make a public declaration, isn't it? It's people are perceiving that the Commission provides them with that platform to make assertions as to how their loved ones are treated.
Yes, Senator, those happen though through the public hearings. and ultimately through the Commissioner's interim and final reports.
So have you refused, given that you've raised the issue of public appearances, have you refused anyone who wishes to appear?
I'm sure there's people, Senator, who expressed an interest in being a witness and have not yet been called as a witness
that's
and may not be
matter.
called as a witness.
Okay, but is anyone that you've said, listen, we can't have you for...
No.
No. Okay. So there's no policy to restrict access to the Commission in terms of public, other than time and
No,
all the
quite the opposite,
practicalities?
Senator. Anyone can make a submission, and from those people who make a submission and indicate that they would like to be witnesses before the Royal Commission.
So, look, the reason I raise that is that it's been put to me that there is a concern that the Commission is effectively a whitewash, and that the Defence Department won't be held accountable, and the Veteran Affairs Department won't be held accountable. This is your opportunity to respond to that type of suggestion. What do you say to that?
Well, Senator, the Royal Commission is completely independent of government. The Commissioners are conducting their inquiry within their terms of reference in the letters patent. They are hearing from witnesses, government witnesses, lived experience witnesses. They are certainly investigating all of the issues under their terms of reference, and it is certainly not a whitewash.
Okay, so that you refute that suggestion. And so have you got adequate staff to allow you to do your job properly?
Yes, I think so.
You've not sought additional staff, given the scale of the public response?
No.
No? Do you feel you need extra staff to deal with it?
No, Senator. If we thought we needed extra staff, we would
Right,
approach government.
no, these are straight questions. This is an opportunity for you to respond to that. I mean, these are highly emotional issues that have been raised. Is it true? People are very upset about some of these things. So it's important to actually ascertain your view on the matter. Now, you've opened up, the Commission Chair has opened up some 36 lines of inquiry. Do you have, are you able to provide us with a list on notice of the 36 lines of inquiry that you are pursuing?
Senator, perhaps I can take that on notice, but it's not the case that the Chair has opened them up. In the course of conducting its inquiry, the Commissioners are, of course, assisted by counsel assisting, solicitors assisting and other staff. And they have developed about 36 lines of inquiry which reflect the terms of reference. And I expect, Senator, that more detail about that will be included in the interim report.
So look, that's fair enough and a reasonable answer. The 36 issues that you've identified come from the terms of reference.
Indeed.
And the evidence?
I beg your pardon?
And the evidence?
Indeed, yes. The Commissioners are obviously driven by the evidence they're getting in terms of where their inquiry goes.
I'm led to believe there's 150 notices of urgent action or please explain notices that have been put to Department of Defence and Departments of Veteran Affairs. Is that right?
We issue notices to produce and notices to give. They aren't please explain, they are notices requiring them to provide us with documents and information.
So
I can tell you the numbers if you'd like those, Senator.
Well, no, but it's about 150 is about right.
It's in that ballpark. I think.
Okay.
Yes.
Well, give me the numbers if you've got it easily in hand.
I do. 151.
Okay.
I'm sorry. 151 to 67. 218.
218. All right. Thank you. Now, look, the reason that becomes significant is it's also put to me that in response you've had over 320,000 pages of material to review. Is there any danger that you will be swamped as a result of that type of response from the agencies?
It certainly, I think, Senator, indicates the scale of the enterprise. It's there's a lot of detail there for us to digest, and that's what we're doing.
And have you had time to actually look at them? Those 320,000 pages.
Well, we've been analysing that material.
So you're satisfied with the responses to your notices for urgent action?
We negotiate the timeframes of those notices with the recipients, frequently the Commonwealth.
So the Commonwealth, sorry, which part of the Commonwealth? You mean the departments or who?
Well, it can vary. It can be frequently the Department of Defence, Department of Veterans Affairs. Other arms of the Commonwealth also hold information that's relevant to our inquiry.
So the agencies have all responded to your request in an appropriate manner.
I believe so. I don't think any of them have been not responded to within the agreed time.
Are you still intending to provide your interim report on the 11th of August?
Yes, the commissioners are required to do that by the terms of by the legislation.
So I presume that's not affected by any elections or any other procedural matters?
I don't think any of our operation is affected by the elections.
Okay, so this will continue through the election period, yes?
Certainly.
Okay. So do you think you've been given adequate support by the government agencies to actually undertake your work? I know you're independent, and I know you'll be able to make requests for information but are you satisfied that you're being given sufficient support in terms of the level of assistance, coordination from government and government agencies?
Yes.
And since you've not requested any extra staff, you obviously think you can deal with these issues within the resources you've been provided.
That's our belief at the moment, Senator, yes.
Okay, so there's been this review of McKinsey into the DVA in regard to the claims processing, which was commissioned by the Minister for Veteran Affairs last year. Have you had any consultation in regard to that review?
That review, Senator, was the subject of some evidence that we took at our last hearing block. So we obtained through a notice the report and other documents relating to it, and witnesses who were involved in the creation of that report and others were questioned on it at our last hearing.
So as I understand, that was in February, and the review have actually tendered their report to the government as evidence. Council Assisting lodged a non-publication direction on the application for covering the review. Is that correct?
There were aspects of the report that were subject to a non-publication direction. Yes.
Can you explain why that was necessary?
I can't off the top of my head, Senator, but I believe it related to some names of people who are mentioned in the report. But the report itself we've received and
so there was a
with.
reduction in terms of what these names, and can you indicate to us what the nature of these?
I think I'm going past my memory, Senator. I think I should take that on notice.
If you could,
but I should explain, Senator, we have the unredacted document. This was only about
so you've
the
got
publication
that
of the document.
And that's an in-confidence document. You're not able to publish that document in full?
Well, we published it in full subject to redactions. And
it won't be in full, will it, if it's got redactions
well,
in it? No.
For the moment, that's right. Yes, I certainly couldn't
that's right.
provide it to you other than in redacted form.
So in terms of the application, Council Assisting's lodged a non-publication direction on application covering the review. How's that matter going to be resolved? Because is it contested, the redactions? Are they actually contested by anybody?
I don't believe so, Senator. Again, I really should take this on notice to be sure, but my recollection is
please.
That Council...
And when the report is likely to be released in full, if you could ask, can you take that on notice?
I can do that, yes.
Thank you. Are you able to provide any feedback on the recommendation that the McKinsey's action plan has proposed?
I can't, Senator. The commissioners obviously are
That's a matter for the
including that in their consideration and their inquiry.
So, Council Assisting Peter Gray QC said the inquiry would address delays in processing claims and the backlog of claims, which he, if I'm quoted him correctly, said was unacceptably high. Now, are you aware, and you'll be also aware the Veteran Affairs Minister recently made some public statements before the budget announcements, and that he threatened to resign if he didn't receive $96 million to clear the backlog, which I think he described as a national disgrace. Now, I understand that request was based on the McKinsey's review recommendation. Now, the government's only provided $22 million, an extra 90 staff rather than 145, which will reduce the backlog sometime through to 2024. Now, is it, I think he said it was a token allocation. would the Commission agree with the assessment based on what you actually know of the McKinsey review?
Senator Carr, I'm not sure that that question is in order.
I'm not sure it
You're
is either,
asking
but
for an opinion of Dr. Popple.
I'm still going to try to ask it.
In relation to a matter which is not within the operations or expenditure of the Royal Commission.
It is in this regard.
So do you have
Madam
any
Chair.
other questions?
No, the question goes to this. Does the Commission have a view as to the adequacy of the current processing of the backlog of claims through the DVA?
Senator Carr, that's another way of expressing the same question that I objected
fair enough
to.
question too.
Well, it may not. It may well be fair, but not to Dr. Popple.
I'll ask this: the
So
Commission
Dr.
have
Popple,
a view? And he can answer his own question. Does the Commission have a view?
As you know, it's not within the standing orders to ask officials to express an opinion.
Well, I'm not asking an official. I'm asking, does the Commission have a view?
Well, I would put to you,
and the
Senator
answer could be
Carr,
yes or no.
that question is not in order. If there's any part of the question, Dr. Popple, that is within the scope of your operations.
I might suggest that while it is something that the official secretary and his team may well in time have a view on, that is something that it is appropriate to include at the conclusion of its work, rather than something that should be provided
and that may well
as a
be
running
his answer,
commentary.
if he was given the opportunity to actually answer the question, rather than all these helpful suggestions.
Remember, we're not asking questions in relation to what report the Royal Commission may hand down and the findings of the Royal Commission. Dr. Popple is here today to talk about the operations of the Royal Commission and the expenditure of the Royal Commission. So within that context, I don't think that question is in order. Senator Carr, do you have any other questions?
Does the Commission have a view about the backlog of claims that's currently being experienced in DVA?
Senator, I think I can say that the Commission has publicly, in the context of hearings, expressed concern about the backlog in DVA.
Thank you. And we look forward to your report, which will detail those concerns. Thank you very much. That concludes my questions to the official secretary of the Commission. Thank you.
Thank you very much, Senator Carr.
And I want to say something, if I could, before we finish.
Yeah, absolutely. Look, just very briefly to you, Dr. Popple, you're doing some very important work. How do you, could you just give the committee a general update on the functions of the Royal Commission and how your work is being embraced by those impacted by defence and veteran suicide?
Thank you, Senator. Well, the Commission is, in fact, this week and next week in Canberra conducting its fourth block of hearings. So we're hearing from some lived experience witnesses and some expert witnesses about these issues. The Commission has already conducted private sessions in which it's heard directly from people with lived experience in a confidential context. The Commissioners are already preparing their interim report, which has already been mentioned is due in August. We have an inquiries line and a number of counsellors who deal with a large number of people who contact the Commission telling us their stories, expressing their concerns about things. We assist them in how they can engage with the Commission, how they might, for example, make a submission to the Royal Commissioners or indeed seek a private session. So to the last part of your answer, our feedback from that has been, I believe, generally positive. Certainly the feedback we've had from people who've engaged with commissioners in a private session has been positive as well. People have seen that as an excellent opportunity to speak about their experiences in a safe way. And also many of the lived experience witnesses we've had in public hearings have expressed that they have obviously not enjoyed the experience, but the experience was as good as it could have been in the circumstances. And we believe that's partly due to the way that we've engaged with them before, during and after they give their evidence. I don't know if that goes to your question completely, Senator.
Thank you very much, Dr. Popple. Yes, Senator Van.
I've had
few friends go through the process, and they've been, well, not a necessarily a pleasant experience. They said it's echo exactly what you said. So as good as it could be, and quite cathartic, and the support they were given was excellent. So on behalf of veterans and their families, I thank you and the whole Commission.
Thanks very much, Senator Van. That concludes the committee's examination of the Royal Commission into Defence and Veteran Suicide. We thank you very much for your time today and for your evidence and for your exceptional work on behalf of those impacted by the Royal Commission. Thanks very much, Dr. Popple. We are now at the conclusion of our program, but before we adjourn, I do want to give the call to Senator Carr. This is Senator Carr's final appearance in Estimates, final few moments appearing as a senator. And so
well, I don't know about that, but I've got a bit more to.
Well,
but that's, you know, I've still got
in the
June. But
yes, but I meant in the we expect in the Parliament.
Right, thank you.
So, Senator Carr.
Thank you very much, Madam Chair. Look, I somewhat inadequately acknowledged the remarks that have been made by the colleagues on this committee yesterday, and I just want to make sure that I do that properly. And all the members of this committee have all spoken on this question. I do thank each and every one of them individually as to their very gracious remarks. And Senator Stoker sent me a very, very nice letter, which was very, very decent of her to do. But where I really neglected, and I want to correct, is I think we have to acknowledge the work of the Secretariat. Yeah. I was caught a bit off guard yesterday, and speaking off the cuff, and I put that as mitigation. But the fact is that this Secretariat has been quite extraordinary in my experience in over many years on Senate committees, and Sophie Dunstan, as the Secretary of the committee, has coordinated quite an incredible effort on behalf of the Senate. We've had on occasions 11 concurrent inquiries running, including, that's probably 12 if you include the estimates, which are a perpetual motion, of course. And I think that's grossly unfair, and I've made this point on the floor of the chamber. But the manner in which the committee has been able to respond to the demand of the Senate do need to be acknowledged, the professionalism in which they've been able to process the evidence of our inquiries and produce reports of the highest standard, and deal with all the other matters that relate to running the Senate process, which includes dealing with sometimes quite irate citizens who feel that they've not been treated as well as they should have been, because there have been occasions where there's been tens of thousands across the submissions to these processes. The Secretariat has to front those on our behalf. I remember one we had to place an advertisement in the newspapers in regard to visas, pointing out that we were not ombudsmen. There was another occasion where people thought we were coroners, and we were expected to adjudicate on matters that were in fact before coroners, and the Secretariat has to deal with all of those interactions. And I just say, I think we're grossly under-resourced, point I've made on other occasions in other forums, but there has been a tremendous effort on each and every one of you. If I could just acknowledge that the support you give to all of us should be properly acknowledged, and I thank you very much. And I want to thank all of the colleagues for the manner in which we've worked together. We've learned to live with one another in one form or another. So, and the humour with which we now deal with these questions is a marked improvement of what we've seen on other occasions. And it's been, I think, overall a product that's produced a service to the Senate, which, Madam Chair, I want to acknowledge that we have managed to be able to achieve quite substantial progress in that area. So thank you one and all, and thank you for the very kind words that you uttered individually. So thank you.
Well, Senator Carr, on behalf of the committee, again, we wish you all the very best. We know that you will continue to make a very substantial contribution until your term ends on the 30th of June. But again, thank you for everything that you have done for this committee, for your incredible contribution to the Parliament, to the Senate. You certainly have been a warrior in every way. You've been an outstanding member of the Labor Party, an outstanding senator for Victoria. We don't always agree, as we've said before, but in terms of holding the government to account, you certainly do that very, very well, and I just want to express my personal thanks to you for the way in which we have worked together. I agree the Secretariat is outstanding. We are incredibly well supported by a wonderful Secretariat led by Secretary Sophie Dunstan.
Here.
And on that note, I will adjourn these proceedings, and you go with our great and best wishes, Senator Carr.
Thank you very much.
We'll miss you.
We will miss you, Kim. I'll be looking forward to that $100 bet that we made earlier in the proceedings today. I think that's... Yes.
I don't gamble.
I think that's on the hand side, isn't it? I'd like to thank the Minister and the departmental officers for their attendance, and for Hansard Broadcasting, and, as we know, our wonderful Secretariat staff. Just moving a motion to accept the tabled documents received during the day. All those in favour, all those against, that is carried. Senators are reminded that written questions on notice should be provided to the Secretariat by 5 p.m. on Friday, the 15th of April 2022. The hearing is adjourned, and again, thank you.
Thank you, Madam Chair.
Thanks, everyone.